is wrong in the order. Go and comply the order of the court. No. Motion এ রাখো দেখবো
My lord, beg to mention one matter, my lord. This is a state matter. Actually, report was called for. That is on 9th of September 2019 from the police, my lord. And there was an order not to take any coercive measure. So report has been submitted. I want to, the matter may be listed, my lord.
Released for
One matter very urgent. Here matter is that my client has been charged under POCSO Act, but at the time of Alice Hawkins, victim attained the age of 18 years. I have served the copy of mentioning to the state that is kindly in listing I am paying for.
you appeal না কি বলছো রিভিশন না কি বলছো ওটা কি আছে দেখো মোশনে রাখো
May your lordships kindly will mention item number 159 of lordships list today, my lord. I was humbly praying, my lord, because the CRAN is also appearing, my lord, with the main matter. So I was humbly praying, my lord, if the business of the court does not allow the matter to be taken up, my lord, today till 3:30, my lord, can it be taken up, my lord, at 3:30 today, my lord? My interim order is also expiring on, my lord, 30th of November, my lord, at 3:30, my lord, if the business of the court does not allow it. And if it's taken up before that, my lord, I'm lucky in that case.
CRAN
159, my lord.
mention after 3.
Mention after 3?
Yes. If it is not reached, then you mention, we'll extend the order.
Definitely.
Item number 1 and 2.
হয় না কেন নেট তো দেখছি আছে ইন্টারনেট অ্যাক্সেস আছে হ্যাঁ
আমি এটাই উজ্জ্বল আরেকটা আমি উজ্জ্বল সে কথা
এটা কোনটা এডিটা আসো This matter is appearing under the heading for orders. Learned advocate for this petitioner. Case diary submits.
This is the original case diary.
Submits that the only allegation against the petitioner is that the deed of gift in question was kept in her custody. There are no such direct allegations against the petitioner. He seeks for grant of this is renewal.
Earlier it was business for disbursement.
Not item number 2, that is petitioner name is Doyal Roy and others. That was previously dismissed for default.
And what about this petitioner?
Item number 1.
It was also a dismissal.
Also.
Thereafter it was filed before the application bench and interim protection was granted in favor of the petitioner number 1.
Earlier, item number 1 was
Petitioner renews her prayer for bail. হ্যাঁ তারপরে সাবমিশনটা
6 for যেটা
learned advocate for the seeks for grant of anticipatory bail in favor of the petitioner. Learned advocate for the state opposing such prayer submits that the petitioners and others forged the legal year certificate and executed a deed of gift and got executed a deed of gift in her favor. Where are the statements?
Statement page 83, 87.
What is the complicity of this petitioner?
Item number 1, my lord.
1 and 2 are all the same.
One Rita Devi is the purchase.
7
Except
except
of the-
she is the
She is the beneficiary.
beneficiary of that. Is there any
Wife of the
Act
principal,
of
act. Wife of the principal.
act of the petitioner in having the forged documents and thereafter? কি বললো?
What is it? The deed of gift in the favor. Hello, man.
Yes.
Rita Devi was the wife of Principal Akush Nandolal. And she accepted the said gift. Post the legal care certificate and about the
Executed in her favor. He seeks for dismissal of the prayer for anticipatory bail. Here is the case diary and the materials and record. The statement of the witnesses shows that the husband of this petitioner played an active role in issuance of a forged legal year certificate. Save and accept that the deed of gift in question was executed in favor of this petitioner. There are no such specific allegations against this petitioner of
Oh.
obtaining the forged document. Considering the aforesaid, I am inclined to extend the benefit of anticipatory bail in favor of the petitioner. Okay, we'll cooperate with investigating officer. Meet it দেবেন না আবার।
meet the one. We focus with.
দিয়ে দেন তো কাটতে আবার মিট দেবেন না। Cooperate with investigating officer. Disposed of, allowed.
But all the persons. All the
This is in respect of one only.
Oh.
Now going to the second now.
Get.
এটা থাক, second. One টা হলো।
Note করা আছে, note করা আছে।
In item number 2,
Yes, my lord. In item 2, my lord,
what is the role of the Pradhan?
my lord, she issued the
But subsequently
forged.
she has stated that it is a forged document.
Yes, my lord.
Now,
And the
question
husband,
is-
my lord, about the petition
petitioner
number 1.
Petitioner number 1 in the second item
Yes.
is the husband of the
Pradhan.
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 Now he, as per you have submitted that he played an active role in issuance of this forged document.
Yes, my lord. And my lord, he
What is the-
against this petitioner, petitioner number 1, Doyle Roy, there are several previous antecedents, case references are there, my lord, in the memo of evidence.
This nature number, those are 326 and such cases. Number petitioner number 2.
What
that
is
the
petition
Pradhan.
number, against petition number 2?
Petitioner number 2, my lord, there is no previous antecedent.
But she was served the notice under section 35(3). And.
I have heard you yesterday. Learned advocate for the petitioner. Where is the report of the Pradhan?
My lord, report of the case.
Page 89.
89.
She has admitted that this was not issued or the
Yes,
memo number
yes,
does not
yes,
tally with
Yes,
it.
yes, yes.
Learned advocate for the petitioner submits that petitioners submit that the petition number 2 is presently pregnant with 32 weeks, 4 days. She was served with a notice under 35(3) of the BNSS. However, due to her medical condition, she could not comply such notice. By later dated 10th November 2025, she has informed the investigating officer of her predicament. He files a copy of the letter which is taken on record. Later dated 10th November 2020. He further submits that no such notice under section 35(3) of the BNSS has been served upon petition number 1. Referring to a notification of referring to the notification of the scope dated 23rd August 2023, he submits that the police authority is under obligation to serve notice under section 35(3) of the BNSS, within bracket corresponding to section 41 capital A of CRPC. He seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, learned advocate for the state submits that the forged legal year certificate has been issued from the office of the Pradhan. Page number?
Post. Page 25 and 26.
কি বলো? Office of the Pradhan. And the husband of the Pradhan, namely petition number 1, has taken active part in issuance of the said forged legal year certificate, by dint of which the deed of gift was executed. Deed of gift in question was executed. He seeks for dismissal of the prayer for anticipatory bail of the petitioners.
Previous antecedents also there. About regarding petition number 1.
Where is that memo?
Memo of evidence, last page at the top.
The petition number 1 has similar criminal antecedents. Similar
Type of
criminal antecedents. Here is the case diary and the materials on record. It appears that a legal year certificate was issued by petition number 2 on 28th June 2024. During the course of investigation, the petition number 2, being the Pradhan, has filed report that the said document was not issued to Nandolal, not issued under memo number 186 within bracket A BO BAG/FULGP. Be that as it may, upon going through the statement of the witnesses, it is found that the allegations of getting a forged legal year, issuing a forged legal year certificate from the office of the Pradhan is squarely on petition number 1. It is not in dispute that petition number 2 is presently pregnant. Considering the extent of complicity of the petitioner number 2 and on humanitarian ground, I am inclined to extend the benefit of anticipatory bail. Para. So far as petition number 1 is concerned, it has been strenuously argued on behalf of petition number 1 that since no notice under section 35(3) has been BNSS has been issued, the petitioner number 1 is entitled to anticipatory bail. The issuance of a notice under section 35(3) of the BNSS is a procedural step to be taken by the investigating agency and not a substantive right that automatically confers bail or anticipatory bail in favor of the petitioner number 1. Accordingly, the prayer of petitioner number 1, Doyal Roy, stands rejected.
Grateful.
Criminal antecedents se kotha bolbo? The memo of evidence also shows criminal antecedent of. Yes.
Liberty to file the wakalat from the department.
For whom?
But for the petitioner number 1 and 2, there's a change in advocate in this case. So I've got the wakalat number along with the LOC.
Liberty to file. Next without. ওটা 2 তে শুধু হবে না 2 তেই ওকালতনামাটা ফাইল করবো ওটা পুরো লিবার্টি গ্রান্টে ফাইল করবো আইটেম নাম্বার 2 তে 1 2 এর Dragon,
I think number 4.
none appears on behalf of the petitioner. Nor any accommodation has been sought for. On the last occasion, that is 17 November 2025, the petitioner failed to appear. In view of the above, the application being CRM A687 of 2020 stands dismissed for non-prosecution. এটা কি রঞ্জিত নাকি? ঠিক আছে, ডিসমিস।
Item number 6.
नहीं है।
Item number 6, paying for short password of this advocate on his way.
Then, my lord, let be not two dealerships.
Not to.
When he will be available and we'll, okay.
Item number 7. Firstly, we have the allegation that it is on 11/5/2025, while returning from nearby marriage ceremony at midnight, and later harm to the request petitioner entered us in his house.
Service report,
Robbed her and
affidavit of service.
Doctor, upon the victim.
Yes.
I have said
Learned advocate for the petitioner seeks accommodation to file affidavit of service. Let such affidavit of service be filed on the returnable date. In the meantime, state is directed to serve upon the de facto communal victim and file service report. Shakash. এগারোটা মেরেটা আছে না
My lord,
Lordship, I'm paying for a short passover, Lordship.
Who is for the state?
Lordship, Mr. Shoikot Chatterjee and Chotu.
Next row. এটা রাখুন হ্যাঁ এগারোটা মেটাতে দেখলেন
Item number 53.
53 and
They arise out of the same case.
My lord, in these two matters, I appeared for the de facto complaint.
Then this, well, under the old sections would be a case under section 406, 420, 506, 126, that's mischief. 447, that's criminal trespass, and 379. So these are the under the old sections that would be under the IPC section.
Okay.
So primarily the non-bailable sections are 406, 420, and 379. My learned friend is appearing in the other matter, but primarily the charge is under 379. He will be indicted. But these are all under section under 7 years of punishment and are magistrate trial offences. Now, this is a classical case, where a civil proceeding is being intended to be transformed into a criminal proceeding with the sole purpose of creating pressure. Well, the de facto complainant is a developer of lands in this area. I will not use the stronger language that he has the from at least this case, he has the tendency of grabbing lands by paying some pittance and then trying to take over the entire land through litigation, either civil or criminal. Now, in this case, well, before I go into the list of dates, well, I have made a small list of dates for your. Well, if your lordship kindly sees. Well, on 21st of December 2024, an agreement is entered between the petitioner number 1 and 2, in this case, the first case, and the complainant to sell 12.65 acres of land at the rate of rupees 89 lakhs per bigha. Now, the agreement, I will take your lordship to the agreement. The agreement contains 3 schedules. Schedule A relates to land of the petitioners in this case. Schedule B relates to the lands of which my Mr. Chatterjee's client are there. And the petitioner number 1 is in possession of the land in Schedule C. Now, if your lordship kindly sees the part in the said agreement, it was agreed that in that period, this was the A, B, C, D, E, if your lordship kindly goes through. These were the terms under which the payment was to be made for purchase of the first tranche of Schedule A. Well, the Schedule A land comprises of around, the value is 10.58 crores.
Now the agreement for sale has been executed in respect of ABC or only A?
It was a composite agreement for, it was an agreement, not an, yes, agreement by which the sale would take place.
It was if your lordship finds the consideration which arrived at is around 11 crores, which covers the 50 lakhs, which was to be given also as the security deposit and would be at the end adjusted. Now, we have what was suppressed in the FIR is 31st of December 2024. When he paid 36 lakhs, we immediately transferred half bigha in his favor. Then, well, even thereafter on 2 occasions, we have executed 88 decimals of land in his favor beyond the half bigha. That means nearly an acre. So it would be nearly 3 bighas of land which we have executed in his favor. Well, in total, it comes to around 2.53. This is completely suppressed. Then what he does, stops paying. Well, there is a time schedule provided, he completely breaks that. We thereafter inform him that if you are not willing to comply with it, you take back your money, you give us back the land. Or you take that portion of the land, which is for which the excess is there lying with us. He does not go. He does not say anything. We thereafter lodge a complaint with the Matigara police station on 2nd of September 2025. Whenever we get the page numbers, these are the page numbers of the application. So we bring it to the notice of the court that he's trying to grab our land. We have already executed lands in his favor. Beyond that, he's trying to grab the land which is fenced and in our possession. I'll come to those paragraphs. Then we come to know that he's trying to construct permanent structures in the piece of land which is not in his possession. We immediately on the 18th of September, we lodge the complaint before the Matigara police station again. He on the next day files this case. And what is the contents of this case? That he has entered into an agreement, he has paid money, but we are not executing the lands in his favor. And his claim is that he is put in possession of the entire land, and Mr. Chatterjee's client have purportedly attempted to enter and have also stolen. I will take your lordship to their complaint. Well, we received notice. If your lordship now comes to the 3rd page, we have also filed a 144. We have got an order. The complainant thereafter files a title suit for specific performance. In that, your lordship will find, well, that 4/11/2025, he has been granted an interim order whereby we have been restricted from selling the land to any third party. There has been no protection of his possession given by the learned civil court. There was a prayer in the plaint that his possession will be protected. The court did not give that protection. Well, in the meantime, if your lordship now sees, on 25/9/2025, we had also written to the local police station informing about the true situation. And on 29/9, despite being given a notice, we were not given that endorsement, for which we brought it to the notice of the officer in charge. Now, if I may take your lordship to the FIR. So this is the background. I have received money, I have sold him those portions of the land. He has already filed a civil suit for specific performance. He has been protected by an order. Now, kindly, what he wants to really do is to take over the entire piece of land. That's coming to around some 30 bighas of land which he wants to grab by paying for 3 bighas maximum.
So 2.53 of
We have
bighas.
already conveyed.
Bighas.
Yes.
So you say that the amount that has been paid against that, the land extent of land has been transferred.
There is some excess, my lord.
Hmm.
We are also ready to do that. We had informed him. In writing, we had informed him that whatever be the excess amount, pro rata basis, we are ready to also transfer it in your favor. Instead, this case is started, a civil suit is also started. We have no problem with the civil. But kindly consider whether in that context the criminal case is maintainable or not. Well, if your lordship kindly see page 24. That's the FIR.
Yes.
Well, if your lordship kindly takes it up from 25, page 25.
Yes.
On 21st of December 2020, well, the second paragraph. The accused executed a written agreement for sale in favor of my company for transfer of this. The property comprised Schedule A measuring 4.1 acre, Schedule B measuring 8 points this acre, and Schedule C measuring 0.20 acre, together forming a contiguous plot. The agreed consideration was 89 lakhs per bigger for Schedule A and B, and rupees 45 this. At the time of execution, I paid 25 lakhs as advance, which was duly acknowledged by the accused, and further payments were made in speeches against execution of registered conveyances for specific portions of the land. In faithful discharge of my liability, I have continuously and uninterrupted the late payments towards the agreed consideration. Several crores of rupees have already been paid to checks, RTGS, transfers and cash, all duly acknowledged by the accused through signed receipts. Registered conveyances bearing number 971, 972 and 976 of 20 have already been executed in my favor for certain parcels of the property. Additionally, the entire 12.65 acres were placed in my possession, and in this we dispute, and that is a subject matter of a civil dispute already. And in exercise of my contractual rights, I commenced site development, this. He says that he started utilizing that. Then next paragraph. At the time of execution, the accused specifically represent that they had clear marketable title to the land, that is free from encumbrances, and that they would secure necessary permission in respect of tribal lands falling within Schedule 3. Malad, they themselves, knowing the fact that these were owned, that the persons, so far as I am concerned, we are scheduled castes. The Mr. Chatterjee's client is scheduled tribe. This fact was also disclosed in the agreement that these are lands owned by the tribals. The only thing that was promised that necessary permission would be obtained within 120 days from the requisite officer. Here he is saying, as if claiming that he did not know, but that is not so. In respect, they further assured that they would cooperate in executing this and that no third-party rights would be created. Relying on this, I altered my profit, invested large sums, mobilized men, and also planned projects. However, despite my continuance and despite being in lawful, and on 22/7, I was informed by my staff that the accused were showing the very same land to prospective buyers and conducting measurements with intent to sell to outsiders. If he is in possession, then how can I do that? On confronting them, they bluntly stated that they were receiving better offers. They were unwilling to perform the agreement with me. This was the first open indication of their dishonest design to defraud me, despite receiving substantial sums and handing over possession. Then it goes on. Then Malad kindly takes up the third paragraph. This is with regard to 379. Mr. Chatterjee will deal with it further. I further state that on 16/9, Malad has gone back.
Yes.
The accused persons, namely Bimal Chandra Rai, along with his sister Roma Saibo, their staff this, armed with this, unlawfully attempted to forcibly enter into our private, which had been lawfully handed. They threatened my this, and they were in the process, they committed theft of large quantities of construction material, including steel rods, MS shuttering, and this. Now, if I am attempting, if my learned friends, clients had only attempted to enter, how could they steal away all these things? But he will deal with it. Then, my lord, the last paragraph. The accused are now refusing to cooperate in the execution of further land sale deeds, refusing to support the mutation and transfer of land already and are deliberately creating obstacles to frustrate my rights. And then he goes on describing the offences, and he's aware, my lord kindly sees page 27, the last paragraph, the first line of the last paragraph, page 20. Thus, the conduct of the accused is not merely a civil dispute, but discloses grave cognizable offences of cheating and this. Now, after your lordship is do that, your lordship goes through the FIR at your lordship pleasure. After that, I take your lordship to the agreement for sale.
Yes.
Now kindly sees the agreement for sale starts from page 29. Kindly takes it up at 33. I'll not trouble your lordship with the parts. This says about the land ownership and everything. Yes. Now, kindly takes it up from clause 5 at page 33. That's the schedule of payment. How he was required to pay and how I was required to transfer.
Yes.
That the second party shall pay a further sum of rupees. Further sum means in addition to 25 lakhs, which your lordship will get in the second paragraph end of that page. He paid this day a sum of rupees 25 lakhs. The receipt. Now this indenture witnesses the last line of that. Last two lines.
Yes, yes.
Then kindly takes up from paragraph 5. Shall pay a further sum of rupees 36 lakh to the first party within 31/12/24, and the first party simultaneously all shall execute and register in favor of the as there is suggested for a piece measuring half bigha. I have done so. It is his admitted. Then kindly sees 6.
No, after that,
Yes.
it says that and shall also hand over the vacant and peaceful possession of entire.
That is there. But kindly consider, my lord, it was not done. But even if let us assume it was done, will it make out the case of 106 or something?
No, just for the sake of understanding.
Cases in civil suit is that we had not handed over the entire land.
But then there is non-compliance of that clause of the
Yes.
agreement.
Which is a part of that specific performance also.
Okay.
Now kindly see 6. That the second party shall pay a further sum of rupees 1 crore within 31/1, and the first party simultaneously shall execute this in favor of the measuring 1 bigha.
This has been done.
He did not pay it within that time, but still we have transferred it. There is no doubt on that. That's why 88 decimals we have transferred, because ultimately he paid it delayed, but we accepted it and we transferred it in his favor. Then paragraph 7 is also that 1 crore and 1 bigha.
But then these are yet to be transferred in the account.
It has already been transferred.
No. So far as the amount is concerned.
What had happened, he was required to give for 1 crore within a certain period, he did not. He crossed that time limit.
Okay.
The next payment also, he crossed that time limit. But he was to get 2 bighas and then 8. That the second party shall pay a further sum of rupees 2 crore 39 to the first party within 31/5, and the simultaneously in favor of the measuring 2.5 bighas. But if your lordship now sees 6, 7 and 8, it is 4 crore 39. He has never paid me that. He has never paid me that. In total, I think he has paid me 3.82 crores. And that includes the 25 lakhs as also the 36 lakhs. And the total consideration was around 33 crores, 33.78 crores for the entire land. Out of which he has paid me 3.8 8 crores in total. And his intention is to grab the entire land by paying this pittance. 10% he will pay and grab. Now, thereafter, if your lordship kindly sees 9, this he has not complied with at all. But despite that, we transferred.
Okay, 6, 7, and 8, this payment has been made.
No. 8 not in total. 4 it comes to 4.39. He has paid me 3.85 in total.
Okay.
And 3.85 from that, Malad also needs to deduct 25 lakhs and 36 lakhs. That's around 60 lakhs needs to be deducted from that. So 3.20 he had paid me.
Okay.
Now thereafter he has not complied with anything. Well, however, we have transferred in 3 tranches land of around 2.5 bighas. Well, that your lordship will get. We have annexed those at page 39, 54, and 68. I'm not troubling your the scheduled portions. I will only show to your lordship if your lordship permits. The schedules are at
The deeds are page 39.
39, 54, and 68 are the 3 deeds which he has admitted in his FIR also.
Okay. Against the 3 deeds which has been executed, there remains some portion which has to be paid by the complainant.
Civil suit, well, because again 50 lakhs was the initial security deposit he was required to keep in terms of the agreement also. That's in clause 9. Clause 9,
Okay.
Yes. Well, clause 9, if your lordship sees at page 34. Page 34, last line, Miller.
Yes.
Well, it is further. The sentence starts with it is further. They are at the end. It is further stated and clarified in this context that an amount of maximum of rupees 50 lakhs shall only be lying as an advance with the first party of the second party, as against all the entire lands given at any point of time, and the first party shall have to register and convey sale deeds of land in favor of the second party or in the names as shall be suggested nominated by the second party beyond the advance amount of rupees 50 lakhs as and when requested and on demand by the second party for any portion of land in pieces or in full portion as required and requested by the second party from any of the portions under schedule. The said amount of rupees 50 lakhs as an advance with the first party shall be adjusted and deducted from the last and final amount of the transaction and from the last piece and parcel of the land to be registered. So 50 lakhs would remain.
Yes.
Then the other payments. Now, therefore, if that 50 lakhs is also removed from 320, it comes to around 270.
Yes.
And that's if your lordship kindly sees around 3 bighas of land. At the rate of 89, I'm rounding it off to 90 lakhs. So 270 would be really 3 bighas.
Okay.
We have already conveyed around similar to that amount. 88 decimals we have done, which is nearly 3 bighas. And previous to that, we have done half bigha also. Now,
Yes.
kindly takes up from page 82. This was my first complaint. Then on 18th again I file another complaint. If your lordship kindly takes it up from paragraph 84. Well, kindly see page 84, paragraph 10. That was the earlier complaint on second, page 10.
Yes.
Paragraph 10 at page 84. However, he has violated these assurance payments leading to dissatisfaction. Despite multiple contacts, I informed Sandeep Goel that he has the option to cancel the agreement if he disagreed with my conditions, but he refused to respond or take any action regarding the sale agreement. As per point 4 of the agreement, in the event of disputes, the agreement is liable to be cancellation at the purchaser's discretion given Sandeep Goel's default. Natural justice grants me the right to cancel the agreement. Upon cancellation, I will refund any amount made beyond the registry land as per his demand. So I said that if whatever he has taken, he can keep. I will refund whatever if there is any excess. Otherwise, I can give back the entire thing if the agreement is cancelled.
Yes.
So from that, your lordship can also assess the mens rea with regard to 420 also. Now, then again on 18.9, I lodge a complaint which is at 86. Then kindly see paragraph 14 at page 89. The other parts are similar, so I will not trouble your lordship.
Paragraph 14.
14 at page 89 and 15. Again, I informed the police that I have given him that option to cancel. He is not doing so.
Yes.
Well, then I at page 106. In the meantime, FIR was lodged. So I brought the entire facts to the notice of the inspector in charge of Patigoda police station. Well, that is at page 106. I'll not trouble your lordship with that. Well, then they filed the title suit, which is at page 122. Hey, what is it? Page 122, and the prayer portion, if your lordship kindly sees, is at 163. Well, this is the injunction application, page 163 prayer. If your lordship kindly sees, there were two prayers.
Yes.
And the suit was filed 3 days after the lodging of this FIR.
Okay.
Now kindly see 163. What was the interim order that was paid? Interim injunction. A, an order for temporary and ad interim injunction restraining the defendants from creating any sort of interference, obstruction, and annoyance to the plaintiff in its right and peaceful issues, enjoyment and possession of the suit land. This was not granted. What was granted was B. Because otherwise the suit becomes infractions. If I
Where is that order?
You can kindly see at page 14.
Yes.
Last portion, coming to the context of the present suit in the light of facts and the circumstance, it prima facie appears that the said agreement to sell was executed on and is still in force, and both the parties have already performed part of the contract. The defendants, though, have tried to amuse the court by submitting that due to non-performance and fulfillment of the terms of the agreement by the plaintiff, and show its readiness and willingness to get the within the time allowed by the defendants by making the balance. Said agreement stands revoked and is not binding, but this submission cannot be appreciated in the present case. On perusal of the agreement, and this finds a serious tribal issue. But I don't know why time was not of essence, specific time periods, but anyway, I am not here for ventilating against the order. The order your lordship will get at page 17.
Yes.
Restricting us to 7. Now, this is the factual situation. Now, in this context, Miller kindly considers whether a charge under section 420 or 406 is maintainable. Why I say this? Because one of the parameters why your lordship grants anticipatory bail is also the availability of the offence. Now, kindly considers in this case, first of all, 406, he has not entrusted any property. Sale consideration, part sale consideration paid to me cannot be entrusted. Against that, he admits that I have sold him land. That is an admitted position.
Yes.
The second submission, whether case under section 420 is made out or not. On a very similar situation, the Honorable Supreme, I'm just relying on this judgment because it clinches the issue, There are two others. I will only give the citations thereof. Paragraph 2. Kindly see what are the sections under which this FIR was started. 420, 406.
Yes.
Now, what are the facts if your lordship kindly sees paragraph 3? 3 and 4. Respondent number 2 and the applicants entered into an agreement to sell dated 29/6 29/6/2020 with respect to sale of Swami Towers this for a total sale consideration of 5 crores this and an advance payment of rupees 11 lakhs, that is 5 lakhs in cash and rupees 6 lakhs by way of check for the later. Further, respondent number 2 agreed to make the payment of rupees 1 crore but this and the balance amount of this beginning as per his convenience. The entire payment was to be made within 18 months from the date of execution of the agreement for sale. It appears that the sale was not executed. Respondent number 2 filed an FIR on 24/5/2022, details of which have already been stated in the opening paragraph. Well, so this was, I will not trouble your lordship with that. Then kindly see paragraph 5. Soon thereafter, respondent number 2 has initiated a civil suit for relief of specific performance of the contract against the appellants in June 2023, which is registered as this. The said suit is still pending. The suit is also filed on the basis of the same agreement to sell with similar facts as stated in the complaint. Same as ours. Very, so I would say similar, very similar. Then kindly see 6. As already indicated above, a perusal of the complaint which has been registered as the FIR does not spell out any element or ingredient of cheating or breach of trust. Mere non-performance of an agreement to sell by itself does not amount to cheating and breach of trust. Respondent number 2 has an adequate remedy of filing a civil for relief of specific performance of a contract which he has already made, and the suit is still pending. The FIR only appears to be an arm twisting mechanism to pressurize the appellants to execute the sale deal or to extract money. Every civil wrong cannot be converted into a criminal wrong. As we find in this present case, respondent number 2 is trying to abuse the criminal machinery for ulterior motives. It is not his case that the appellant duped him to pay the advance amount and enter into an agreement for sale.
Yes.
But then paragraph 9. From a
Yes.
paragraph 9. From the bare perusal of the FIR, it is evident that there was no act of cheating, that is, the complainant was nowhere fraudulently induced or dishonestly deceived by the appellants. A commercial transaction took place between the parties during which the parties consensually agreed for the sale of the property of their paid the part consideration. The defaulting payment of their loan dues on the part of the appellant is not reflective of their deceitful intention towards it. Mere non-registration of the sale or its refusal cannot amount to cheating. The delivery of the advance payment towards consideration was made in furtherance of an agreement to sell and it is not the case of the respondent that he was in any way deceived or due to make such payment to the appellants. It is a civil dispute and gives rise to the complainant's right to resort to the remedies provided under civil law by filing a suit for specific performance, which was done in this case and in our case. Why there is no duping? Because there is no dispute with regard to the title.
Yes.
In our case also, he does not dispute my title. That's why, well, kindly see the contradictory stand he takes. In the civil courts, he goes and says, I want specific performance of this contract, thereby accepting my title, my ability to transfer and everything. Here, he comes and says, ultimately, if he says it's a charge under 420, he's saying I'm attempting fraud by entering into this agreement. He's saying this agreement is a product of fraud. So kindly see, both cannot coexist. In the civil suit, he says this agreement is valid, legal, everything. Here he tries to show that the agreement is a product of fraud.
Yes.
That is the dichotomy which stands there in the criminal and the civil. Now, kindly see 12. Paragraph 12 of that also. I'm sorry, Malad, I'm taking a bit of your much time. In the present case, the appellants were not trusted with any property by the respondent number 2 complainant. The only delivery made was a part payment towards an agreement to sell between. The amount paid towards consideration cannot be said to have been entrusted with the appellants by respondent number 2. 406. Additionally, merely because they are refusing, it does not amount to misappropriation of their funds. Since there was no entrustment of property, the offence of misappropriation of such property and therefore criminal cannot be said to have been made out.
Yes.
Therefore, the act of at best constitutes, paragraph 13, 4th line, the act of the appellant at best constitutes and does not call for any criminal action. Civil wrong cannot be given merely to coerce the appellant's interest. The judicial process cannot be used as a tool to enforce specific performance of an agreement. Respondent has ample and he has already by filing a which is pending actually. Thus, such cannot. In fact, this was quashed. I am not asking. FIR was quashed. I am not paying for that. I am only saying that I may be the investigation may continue. I may be given that relief of anticipatory rate. Well, there were 2 other judgments on this issue. I will only provide the citations and copies thereof. They are 2025 SCC online, SC 2058. Only copy the changes.
2058.
I've handed over the copy, my lord. And the other is 2025 SCC online 1474. Similar, where agreement to sell, failure to register, what are the consequences? In all of them, the Honorable Supreme Court has said, it about 1%. You know it. Now, in a very similar situation also, well, a bench of this honorable court are dealing with a matter of a similar nature and of the same relief. Well, was pleased to also grant anticipatory bail in the same context. Well, it was a division bench at that time because the rules provided for that. It was a bench of Justice Bagchi and Justice Baroda. And I gather your lordship has also passed an order yesterday also on the issue of contractual liabilities and whether. Now, the other issue I would say, yes, it's a very small, but everything, yes, very, very succinctly put.
Yes.
Well, the other issue is that, well, after all, this is a document-based investigation.
Yes.
It relates to whether I have received money that is in his possession, in the possession of the de facto complainant of this state, whether there was execution, there is no denial of the executions by us of the agreement. In various letters written to the police, we have admitted the same. We have also expressed that we do not, if there is some excess amount with us, let us sit and we can refund it or we can even convey land for that. We have written to the police stating that.
Yes.
Now, therefore, in those circumstances, kindly considers whether a charge of 406, 420, whether I need to be in custody or face custodial interrogation for these purposes, when they have already approached the civil court for similar. and petitioner number 2 is a lady. Against her, except execution of the agreement, there is nothing. There is nothing
He's the wife of Bimal.
of people. Therefore, on any condition, my lord, I was only praying if your lordship kindly grants me anticipatory bail. Well, it's subject to a right of reply. My learned friend is in the
Six minutes, I'll just take a few minutes just to address your lordships. But so far as item 56 is concerned, my lord, there are a number of petitions. My lord, petitioner number 1, my lord, your lordship will see from the agreement of sale itself, from my lord, the previous brief also, my lord, the same agreement for sale. The petitioners in my lord item 56, my lord, none of them were my lord parties to that agreement. None of them. Although they hold my lord pieces of my lord lands which are my lord adjacent or contiguous to the lands owned by my lord the petitioners in Mr. Ganguly's client's matter. My lord, but they were not formally made parties in the agreement for sale. The only connection, my lord, is that the petitioner number 1, my lord, is lady, my lord, Roma. She is a cousin of petitioner number 1 in Mr. Ganguly's matter. Wala is, my lord, Bimal's, my lord, cousin. Is my lord the petitioner number 1. And my lord, she is a widow and she belongs, my lord, to the scheduled tribe.
Okay, she accompanied, as per the allegations, if I say accompanied.
In the FIR, she says, in the FIR, my lord, de facto complainant says that since they are also holders of contiguous pieces of land, Bimal was acting as their mouthpiece to enter into a valid legal transaction with the de facto complainant. Now, my lord, so far as the petitioner number 1 in my matter is concerned, my lord, kindly see, my lord, my learned friend has shown your lordship, my lord, Radheshan. In Radheshan, my lord, the Supreme Court uses a very strong word, which is arm twisting. Now, my lord, this is a classic case, my lord, where this, my lord, high and mighty builders, my lord, of this region, my lord, are arm twisting, my lord, scheduled caste people, my lord, and scheduled tribe people, my lord, like me, my lord, I am a widow, I am a tribal, to, my lord, convey our property, my lord, at my lord peanuts. And this is exactly what is the modus operandi. And my lord, that is, and the other petitioners also, my lord, in the second matter, my lord, item 56, they all belong to, my lord, the scheduled caste or the scheduled tribe community, my lord. And none of them, my lord, 2 to 16, petitioner numbers 2 to 16, my lord, none of them, my lord, are named in the FIR. And we have served, my lord, 35-3 notices. We try to cooperate. The IO doesn't cooperate, my lord. The IO doesn't cooperate. This is the
See what
difficult
state
thing, my lord.
says.
That is why, my lord, your lordship will recollect, Supreme Court had to deliver judgments like Santosh. Where, my lord, the Supreme Court says that the cooperation cannot be to the satisfaction of the IO. Or cooperation doesn't mean that you have to confess a crime. So, my lord, where the petitioners here are not even parties to the agreement, and the, my lord, feeble allegation made against them in the FIR, if your lordship sees the FIR, is they were trying to enter the land and take away property. My lord, it is our land. How can I steal in my own land? My lord, here somebody else is committing theft.
attempted to force it.
And yes, and the look, I have never seen a 379 read with 511, my lord. 376, 511, one can understand. And your lordship, in my anticipatory bail application, your lordship will very kindly, my lord, once, my lord, come to page, my lord, 59. My lord, even I have lodged a complaint. Kindly see what kind of, my lord, treatment, my lord, these high and mighty builders, my lord, are perpetrating, my lord. Kindly have, my lord, page 59.
Yes.
Kindly see para 1, my lord, I have said that I belong to the ST community. Para 2, my lord, I have named my caste. Kindly see para 4. Few days ago, on 16 September, local persons without legal right encroached my land and they wrongfully dispossessed me most illegally and unauthorizedly from my land, and they also threatening me with dire consequences by saying as, well, I am not reading it, so and so, so and so, so and so, and putting fear with me in dire consequences. My lord, I make a specific request in para 9 and 10 to initiate proceedings, my lord, under the SC and ST Act. My lord, next page, my lord, page 61. I make that specific request. See, that if, my lord, this is disclosing a cognizable offence, my lord, they should have registered an FIR. They do not do so, my lord. Their cooperation is towards somebody else, my lord. And immediately after this, my lord, what the police does is serves us a 35 notice. My lord, this is the way, my lord, people are being handled. My lord, whether, my lord, any case of cheating or criminal breach of trust is made out.
Yes.
Roma, my lord, one more allegation that my learned friends might make is your lordship, my lord, knows civil law, my lord, much better than me, my lord. Now, my lord, the standard operating procedure is if somebody's land or house has to be grabbed, just get hold of his account number. If you can get hold of it, transfer 5 or 10 lakhs there and then file a suit. Exactly that has happened initially through their mercenaries. They sent me a check of petitioner number 1, sent a check of 10 lakhs. I didn't accept that. I didn't encash that. They got hold of my account number, did an RTGS of 10 lakhs. And I am the only person, petitioner number 1 is the only person who has been made defendant number 3. Kindly see, my lord, this scheme of things, my lord. This is how, my lord, large, my lord, plots of land are grabbed. And, my lord, multi-stories are raised thereon by this high and mighty focus. I was praying for it. Page 44, my lord. In under section 144, my lord. We have also, my lord, initiated proceedings under 144, my lord, like them, because of the issue of breach of peace, my lord, in my locale.
Page 44.
Yes, kindly have page 44 once. First, my lord, this is prior to my section 144 proceedings.
Your application or the other?
Which application you are not should be seen?
His application, his.
Oh, his is page 40.
Mine, page 44.
No, 44 is something else.
হ্যাঁ করেছে সেটা তাহলে 10 লাখ টাকা যে
Yes.
করে ঢুকে দিয়ে
Yes.
এরকম সাইন করো
Then, yes, this is also in the other one. My lord, lordship, this is 44, para 12. There, my lord, Bimol
Oh.
also has given this input to the police that his cousin has been dealt with in this way and 10 lakh rupees has been forcefully put into her account
and this was a letter of the 2nd of September.
prior to the FR.
Okay. Yes.
Lordship, here is the case of the prosecutions that they are entering the agreement and subsequently failed. And the specific case has been started. And the police had been to the spot and collected some constitutional statement. Lordship, can you see page number 56, 59? From the constitutional statement, it is named that the petitioner, Bimol and any associate, all of the one fencing room which was used by the defective complainant. This is only, and they have stated that there is a dispute between the owner of the promoter builder and the Bimol, and they did not pay the amount, that's why they blocked, and this is the entire one system statement your lordships. Lordships 56, 59, 32 mentioned that there is a dispute between the parties regarding the payment. Developer did not pay the entire amount, they have stated the staff of the builder, your lordships.
Okay.
And lordships, thereafter the CD lordships, I will invite your lordships. Page 195, your lordship, last page of the CD, your lordships. And they have filed one specific performance civil suit regarding that matter. The dispute is going on before the civil judge, senior division lordships. And others raised are the 34 notice issued to the petitioner.
Yes.
Lord, briefly, my lord, what my learned seniors had, the story that was portrayed by my learned seniors, the actual fact is, my lord, completely different. My lord knows very well, my lord, the surrounding corridor of Shiliguri, throughout, my lord, Fulbari to Matigara, the surrounding corridor is, my lord, a den of the land mafia. This is how, my lord, this is exactly how, my lord, moneyed men are duped by these persons. Now, my lord has seen from the FIR itself that there are 3 schedules of land. Schedule A, Schedule B, and Schedule C. Schedule B precisely, my lord, was a tribal land. Now, my lord knows very well that as per the West Bengal Land Reforms Act, if one has to sell, if a tribal person has to sell off their own land, they have to be in a financially destitute situation. That is what the application has to state before the BCWO, and accordingly, a permission has to be taken for transferring the land. Now, my lord, my client, he is a developer. He is concerned with, my lord, raising his project. Now, my lord, he is duped by this person by portraying that 2 schedules of land are perfectly marketable, but one schedule is a tribal land, which belongs to one of them. Now, my lord, the portrayal that they, my lord, show to us is that they're in a financially destitute situation. They are in immediate need of funds. And accordingly, they would make the appropriate prayer before the BCWO and will not obtain the permission. And after which Schedule B and Schedule C would also be transferred to me.
C is not the tribal land.
C is not the tribal land. From A, my lord, certain part of, my lord, around 88 decimals was sold off to me. The entire consideration with regard to that has been paid by me. But the portrayal that was made to me was that they are in a financially destitute situation and they are in immediate need of funds. I had paid them accordingly, my lord, the agreement was executed. They portrayed to me that they would obtain the permission, but later on, what we came to know is that they are in no such financially destitute situation, which is why, my lord, when they approached the concerned BCWO, they were, my lord, the BCWO refused to entertain them. Accordingly, my lord, this is what has happened to us. Now, my lord takes up the FIR once. I do not have the copy of the, my lord, application. Takes up the FIR.
So B schedule, B is not a schedule in the civil suit.
B is a schedule. The civil suit, my lord, is with regard to the entire agreement. Agreement specified all these schedules, my lord.
But then
Now, my lord,
the B cannot be executed.
no, my lord, that would be subject to the permission of the BCWO. That would certainly how the judgment would be passed. Because that entire performance would be subject to the, my lord, tribal permission of.
But
So-
that has been refused, you say.
My lord, they had approached the BCWO. That is the, my lord, information that we have. They had approached the BCWO, but that was refused to them at this juncture, which is why, my lord, we were constrained to file the civil suit. So that through court, they can show as to how they are financially destitute and whether we are at all entitled to that Schedule B land. This is exactly, my lord, the deception that was, my lord, done to us. Now, my lord takes up the FIR. But I do not have the copy of the application. The 3rd page of the FIR, my lord, the 2nd paragraph. It starts with, my lord, on 24th of July 25. Yeah.
Yes.
My lord, initially they show that they are poor people. Now, my lord, on 24th of July 25, what do they tell me? On 24th of July 25, the accused sent me a note sheet on WhatsApp containing unilateral, whimsical, and coercive conditions. These included demands for enhanced rate of land, restrictions on construction, compulsory purchase of materials from them at inflated prices, escalations beyond agreed consideration, and even a clause enabling them to cancel the entire deal by refunding my money at their discretion. These terms were never part of the contract, and the imposition of such arbitrary conditions after receipt of huge amounts is a clear attempt of extortion and cheating. Now, my lord knows very well, my lord, this land is, my lord, surrounded by a river. And, my lord, riverbeds at this moment are, my lord, under the control of the sand mafia. This is exactly why I was duped into this transaction, because they had to sell me these construction materials at inflated prices. If I do not do that, then they would engage their, my lord, antisocial elements and, my lord, encroach into my property and, my lord, a precarious situation would arise at the property. That is exactly how, my lord, the land mafia operates. My lord, thereafter takes up, my lord, the next page of the FIR, the last paragraph, my lord. The my lord knows very well, just because I have pursued a civil remedy does not bar any criminal action. That law is settled, my lord. In this case, my lord, it is, my lord, precisely clear that I have been duped by the land mafia. So if I have been duped, if I have been cheated, that is the subject matter of the investigation. During the investigation, them not complying with the section 35 notice and coming straight away in an application for anticipatory bail, my lord, that cannot be entertained. Let them join the investigation, let them comply with that 35 notice, and thereafter come in. At this moment, my lord, there, because the primary consideration for an anticipatory bail application is the apprehension of arrest. Where is the apprehension, my lord? If they are themselves admitting that they have been served with 35(3) notices, there exists no apprehension, my lord, of arrest. They first have to comply with that, then they have to come up before this honorable court and show whether there actually will not exist any apprehension for arrest. So, my lord, this paragraph, this says, thus the conduct of the accused is not merely a civil dispute but discloses grave cognizable offences of cheating, breach of trust, misappropriation, conspiracy, common intention and intimidation, all punishable under the BNS. The dishonest intention existed from the inception and has been carried out through continuous acts of deception, coercion and misappropriation. Now, my lord, this is on the merits. Now, my lord, that being said, my lord, the precarious situation that we had encountered yesterday, my lord, has seen, my lord, two judgments of the Kerala High Court and the Madras High Court with regard to, my lord, affirmation of the affidavits. Now, my lord, in these two petitions, in item 53, my lord, Bimal Chandra, the affidavit has been affirmed by the son.
The question cropped up yesterday in an application where two judgments of one of Madras High Court and another of Kerala High Court was placed before this court as to whether an application under 438 can be filed at the instance of a third party. That means the affidavit shown by the third party in place of the applicant. There the court has emphasized on the word that has been used in 438, he may apply.
Perhaps the judgment of this honorable court.
Bhubaneswar.
Was not placed.
No, that was not
My lord,
placed.
that is what I am
coming up
placing, my
yesterday.
lord.
Now it is coming out. There it says that the Todbikar, who has to be a close relative, however, can.
No, my lord, that is certain.
Yes.
I'll read out the relevant paragraph. In Bhubaneswar Datta, my lord, yes.
Interpreted section 4, subsection 2
Sir.
of the Codes Act.
I think it's Justice Amit Talukdar.
No, it's, I think, Justice, no,
My lord,
Bhagwati Prasad Banerjee and Julie Brown.
takes up.
This is Bhubaneswar.
Yes, my lord, Bhubaneswar. My lord, in Bhubaneswar Datta, what our honorable High Court was encountered with was, my lord, whether an affirmation of an affidavit in an anticipatory bail application would be hit by, my lord, Article 23 of the Constitution.
Subject to correction. Our High Court said that the procedure was being tried to be streamlined to avoid doubts from the system. Now, my lord, can the son who is affirming for the father be termed as a doubt? Is the legal question, my lord, that perhaps my learned friend has to ask himself.
Now, my lord, takes up para 15 of the judgment at page 5, my lord.
In fact, my lord, in Bhubaneswar Datta, the division bench says that your lordship knows, my lord, under the Oaths Act, under 3 subsection 2 of the Oaths Act, my lord, there is a bar on an accused to affirm an affidavit with regard to his own application. Bhubaneswar is carving out an exception for the accused that in an anticipatory bail, the additional advantage that you are being given is you yourself can also affirm the affidavit.
My lord, page.
Usually, what we learn from our seniors is in quashing petitions, the accused doesn't affirm the affidavit because it is a statement that he is making. Later, it may be binding on him.
Sir, I mean, 2 minutes to
the only difference may carved out in Bhubaneswar is the accused also can.
Okay.
Now, my lord, para 15 at page 5. First, my lord.
Yes.
May I read out, my lord?
These are arguments.
My lord, in considering the provisions of section 438 of the Code of Criminal Procedure, the court cannot ignore the expression he may apply to the court. In construing the statute, the court is bound to give effect to each and every words used in the statute. The expression he may apply could not be construed as may on application by or on behalf of a person. Exactly, my lord, the question that your lordship had fallen from your lordship. Whether he may apply would also mean he may on his behalf.
You can mean that.
So, my lord, or the expression he cannot mean that he includes a stranger or a todbirkar or a tout or a middleman. Every word of the statute must be given its normal and literal meaning. The expression, in our view, he, by any stretch of imagination, cannot be allowed to include any other person excepting as provided under the Civil Procedure Code, wherein the applicant includes the applicant's holder of power of attorney, or when he appoints an agent as provided under the law when he is unable to come to the court. If we have to hold the expression he includes Todbirkar and others, in that event we have to construe the words that he may affirm an affidavit and file an application for anticipatory bail on behalf of the person to whom he has reasons to believe that he may be arrested on accusation of a non-bailable offence. In our view, the expression he could not include and mean a stranger or a Todbirkar or a middleman. There may be cases where a person may be old and disabled and cannot undertake a long journey to affirm an affidavit, not the case here, my lord. In such cases, he may authorize one of his relation or friend and who may be briefed by him, but in each and every case, the said principle cannot apply and the applicant has to file the application for anticipatory bail by swearing an affidavit himself. This, my lord, clears the doubt. Section 437 of the Code of Criminal Procedure does not contemplate any written application and it may be made by an oral application. This view was taken by the Supreme Court in the case of R.K. Nabachandra Singh versus Manipur administration reported in such and the position has been correctly highlighted. Section 19, subsection 17 of the Court Fees Act provides that an application for bail has to be signed by an advocate or by the prisoner in custody or other person in duress or under restraint of any court or officer. So the legislature has taken care of such a situation when a person is in custody. However, my lord, when a person is free, then he has to come himself. In exceptional cases, he can authorize a relation or a friend, but in our case, there is no such authorization. His son comes up and says that I want to affirm the affidavit for my father. In my lord, item number 56, the nephew comes forward and says that he was nephew of the petitioner number 1 in item 56 comes up and says that he wants to affirm the affidavit. Now, my lord, para 23 thereafter, the ultimate conclusions. Para 23, my lord, page 7.
I will reply to it after my learning.
Yes, sure. After hearing Mr. Bolai Chandra Rai, Mr. Milan Kumar Mukherjee and Mr. Qazi Safiullah, learned public prosecutor, and other learned advocates, and after considering the various case laws in the provisions of Article 23 of the Constitution of India and the provisions of the Oaths Act and the Criminal Procedure Code, we are clearly of the view that there is no bar for the applicants to affirm an affidavit for filing an application under 438 of the Code of Criminal Procedure, and that mere affirmation of an affidavit in support of the application does not amount to any testimonial compulsion, and that the same also does not come within the purview of the provisions of section 4.2 of the Oaths Act, which is only confined to criminal proceedings, or in other words, in courts of trial and not in courts of the investigation. In that view of the matter, the Todbirkar or an agent cannot affirm an affidavit in an application for anticipatory bail, and in each and every case, the applicant has to affirm it before the oath commissioner of this court or before any magistrate who is competent to administer an oath, and in case of genuine difficulty, the same could be affirmed by an agent duly authorized by the applicant in accordance with law as provided in the Civil Procedure Code. We also hold that this court and no other court in the state can entertain an application for anticipatory bail if it is affirmed by a mere Todbirkar, and no such application can be entertained unless it is supported by an affidavit by the applicant or by his duly authorized agent in accordance with law and not by the Todbirkar or a middleman. Since this practice, which is in our view, is contrary to the law and is continuing for a long time, we do not propose to reject such applications which are in the list and pending before this court, and that those cases can be taken up only after a supporting affidavit is affirmed by the applicant or by the persons who are duly authorized by the applicant in accordance with law 2 weeks from today. So, my lord, the conclusions arrived at in this judgment is that a family or a relation has to be, my lord, covered by the, my lord, situations elucidated in, my lord, para 15 of the judgment, And my lord, para 23 passes those directions that a person has to come himself, and in his absence, Code of Civil Procedure will apply, and an appropriately authorized agent can only affirm the affidavit. In the absence of such situation, my lord, this application is not maintainable. Both these applications, my lord, are not maintainable unless these defects are cured.
Yes.
Yes, yes.
That I will only rely on one sentence in paragraph 23, which is the issue. It's a judgment by the Honorable Division Bench, and he sees, it starts with, we also hold. This is a finding of a court. We also hold, that's, my lord, 1, 2, 3, 4, 5, 6.
Yes, yes, we also hold.
Also hold that this court and no other court in this state can entertain. So this court only can entertain. What can it entertain? An application for anticipatory bail if it is affirmed by a mere todbirkar. And no such application can be entertained unless it is supported by an affidavit by the todbirkar or by his duly authorized agent in accordance with law and not by the todbirkar or a middleman. So a tout cannot, an unrelated person cannot. But this practice can be undertaken by this honorable. This is being held. We also hold that this court and no other court in this state. So if we continue, we also hold that this court can entertain an application for anticipatory bail if it is affirmed by a mere todbirkar. And no such application can be entertained unless it is supported by an affidavit by the applicant or by his duly authorized agent in accordance with law, which has been done. In any other court, before the learned sessions court, it cannot happen. Before the learned magistrate, it cannot happen.
Oh, this has two parts.
Yes.
One, if it is filed before the honorable court, Mayor Todbirkar can file anticipatory bail.
Otherwise, in other courts, it cannot.
Okay.
Well, that seems to be the reading, with great subject to correction by your lordship, and what my learned friend in fact had said. There are many other observations, but ultimately the division bench holds that it is this court which can entertain an application for anticipatory bail if it is affirmed by a mere todbirkar. That's why a non exclusion clause is involved and no other court in this field. And my lord knows that this has been the practice before this honorable court. Otherwise, if a person has to come and affirm over here, the first thing will be that there will be a police outpost near the affirmation office. Where police will stand with all the pictures. Whenever one comes, yes, let us go.
Now, this was argued yesterday.
Yes, I understand. These are all
Madras and this Madras High Court and Kerala High Court have claimed that
desperation.
My lord, one of my seniors used to tell me that when an argument of maintainability is being agitated after the argument on merits, then it is always an argument of desperation.
Otherwise, it's a point of development.
Bhuvneshwar Datta being cited by my learned friend, my lord, he has shot him on his own foot.
So this he will place tomorrow because his matter is coming up tomorrow on this issue. Okay, awesome. It is 817. Item number 53. Learned senior advocate appearing on behalf of the petitioners submits that petitioners submits that an agreement for sale of land comprised within
comprising 12.65 acres.
12.65 acres
In total.
within Mouja Rajpairi was executed between the complainant and the petitioners.
What's happening?
Huh?
Maybe.
The complainant paid at a total consideration price of 33.78 crores. The complainant paid an amount of certain portion of the amount, and these separate deeds have already been executed pursuant to such agreement for sale. The de facto complainant is a developer who has entered into the agreement for sale for development of the land. This is a clear case where a civil dispute has been given a criminal color. There is no such mens rea so far as the offense under 420, cheating under section 420 of IPC is concerned. Furthermore, a part payment pursuant to agreement for sale cannot be construed to be entrustment, and in no stretch of imagination be misappropriation of funds. The complainant, after filing of the FIR, has lodged a civil suit before which court this is being typed.
Civil judge senior division.
Learned civil judge, senior division.
Before the learned civil judge senior division at Siliguri, being title suit number 116 of 2025, seeking specific performance of the agreement for sale dated 21st December 2024. উপরে যখন প্রথম লাইনটা আছে ওখানে ডেটটা দিয়ে দিন তো 21st December 2024. The averments made in this suit is completely contrary to the allegations made in the letter of complaint.
No, my lord, your lordship is, no, they're similar.
The allegations,
I only say that once he has gone for specific performance, he admits that the agreement is valid. And then he
ঠিক আছে,
cannot say
কেটে
it's
দিন,
a
ওটা কেটে দিন.
fraud.
Yes. On one hand, in the civil suit, the complainant seeks for specific performance of the agreement for sale. And on the other hand, in the letter of complaint, he alleges he was made to execute the agreement for sale basing on false representation. The petitioners, such self-contradictory claims prove beyond doubt that the instant case is nothing but an arm-twisting tactics. Mayor, non-performance of an agreement for sale by itself does not amount to cheating and breach of trust. The remedy of a party lies in a civil suit for relief for specific performance of contract, and in the instant case, the same has already been done by the complainant. In the instant case, a commercial transaction has taken place between the parties, which the parties consensually agreed for sale of a certain portion of property. The act of the petitioners at best constitute a civil wrong and does not call for any criminal action against them. To buttress his contention, he relies on the decision of the Honorable Supreme Court. It into decision in the one is 2024 SCC Online 2311, 2025 SCC Online SC 2058, 2025 SCC Online SC 1474. In light of his aforesaid submissions, he seeks for grant of anticipatory bail in favor of the petitioner. Opposing such prayer for anticipatory bail, learned advocate for the state submits that the complainant having paid a considerable amount of money, the land in question has not been registered in his favor. He seeks for dismissal of the application. Learned advocate for de facto complainant opposing the prayer for anticipatory bail submits that the complainant has been duped by the petitioners, who, knowing fully well that the land within Schedule B needs further clarification and permission from what is the full form BCWO? Permission from backward class welfare officer for transferring the same in favor of the petitioners. In favor of the complainant. However, without there being any permission from the authority, the complainant has been deluded to part with a consideration price. Further, the petitioners have not complied with the notice under section 35(3) of the BNSS. He also indicates that the application has been affirmed by, who is the person?
Son of the petitioner.
Affirmed by the son of the petitioner, and therefore the application under 438 CRPC is not maintainable. In support of his contention, he relies on decision of this court passed in Bhubaneswar Datta and others, reported in 1998 SCC Online Calcutta 13. In reply,
I'm sorry, Miller, that I could not reply to the other issue. If your lordship only permits me, or your lordship records, that so far as his allegation that we had approached, it was refused. that is not part of his FIR, not part of his claim.
Yeah. In reply to the contention of raised by learned advocate for de facto complainant at the outset, learned senior advocate appearing for the petitioners submits that as per the decision of Bonneshwar Datta Supra, this honorable court can entertain an application for anticipatory bail if it is affirmed by a mere Tadbirkar and no other court. Therefore, the further, the rejection of permission by the BCWO is not contended in the FIR.
And the other is that he says I have not complied with 35(3). I deny that because I had written to the.
He further submits that the petitioners all along tried to comply the notice under 35(3) of BNSS.
And no endorsement was given despite.
And in support of the same, a letter has also been issued to the inspector in charge of Matigara police station. Here is the case diary and the materials on record. Admittedly, an agreement for sale was executed between the complainant and the petitioners on certain terms and conditions for sale of land within Mauja Rajpauri, PS Matigara. There is also no quarrel of this fact that 3 deeds of certain portion of land has already been executed in favor of the complainant pursuant to the agreement for sale as part performance. Undisputedly, the petitioner for specific performance of contract filed a civil suit being title suit number such and such. Thus, the disputes pertaining to the present case arise out of contractual obligation. This court finds substance in submission of Mr. Ganguly, learned senior advocate appearing for the petition relying on decisions Supra. Allowed. 56 টা দিন আপনার learned senior advocate with regard to the maintainability point in Bonneshwar Supra, this court para 23. Therefore, such argument does not stand to reason. 23 টা খুব করব 56 learned senior advocate appearing for the petitioners at the outset submits that they are not part of the agreement for sale. The petition number 1 is the cousin sister of Bimal Chandra Rai, who is one of the party to the agreement for sale. The only allegation as made in the FIR is attempt to theft. The petitioners are adjoining landowners.
The petitioner number 1 is an adjoining.
Petitioner number 1 is an adjoining landowner. He seeks for anticipatory bail. Paper off. Allow করবেন allowed similar এতে allowed হবে মেইনটেনেন্স পয়েন্টও এখানে আছে same subdivision all are allowed subject to they will join cooperate with investigating officer.
Thank you. Keep remain out of because he's free to join the investigation.
She will not join, but so far as cooperation is concerned, she will not join investigation. Female ক্ষেত্রে how which petitioners are female?
In my first application, there is petitioner number
ওটা 2 টাইপ আর এখানে হচ্ছে 1
Petitioner numbers 1. Petitioner number 1 in my application, Lord, is a woman.
12 is there.
And
12 is there.
yes, yes.
No, to
One and two.
cooperate with investigating officer, not to join the investigation. We line the thing. Thank
I'm
you.
grateful.
I'm extremely sorry, we have taken up so much of your options, right? And the logics have been extremely patient, not fix a time for us.
Huh?
The council was very kind to fix a
First,
time.
he moved a mention for getting a date.
Yes.
Now, yesterday,
Yes.
you mentioned for getting the time.
I know it most time, most.
Thank you, sir. Thank you, sir.
Next.
মানে পাসওভার আছে না?
I'm for the state lordship.
8 you are there?
I'm for the state lordship.
But allegation is that acting on a source information, the informant apprehended two persons, namely Vijay Shukla and Subhash Shukla. And from their possession, 24 kilo Raja has been recovered. But in respect to the petitioner, nothing has been recovered from the petitioner, present petitioner. And the petitioner, present petitioner is not the entire name. But charge sheet was submitted, and his name has been transferred in the charge sheet. And another point is, the recovery was made without any independent witnesses, and the seizure was made with measures of IC Tinata, the same police station section 50 of and moreover, nothing has been recovered from a possession, charge sheet submitted, so takes on the.
Yes, lordship. Statement of the co-accused petitioner name transferred, two accused persons was arrested, Vijay Shikdar and Subhashis. Their position, the Gada was recovered, charge sheet submitted with
Other co-accused granted bail.
in this three accused persons.
2 or 1. Learned advocate for the petitioner submits that
The accused petitioner is a supplier of Gada, lordship. Supplier.
submits that the petitioner was not named in the FIR, but subsequently his name has transpired from the statement of the co-accused, and charge sheet has been filed against him under sections 20B2C/27 capital A of the NDPS Act, narcotics. Hold a minute. The recovery of the alleged contraband substances have been made from the possession of the persons apprehended. এটা quantity জানি contraband substances of 24 kgs.
24.755.
There is no such recovery from the exclusive possession of this petitioner. He seeks for grant of anticipatory bail. What is your name? What is your name?
But my name is.
Vishwanath Devnath.
Recovery was proper on Vijay Shikdar and
Subhashis. Seizure list page 17, lordship.
learned advocate for the state also submits that the name of the petitioner has transpired from the statement of the co-accused. However, considering the nature of offence, he seeks for dismissal of the application. Here is the case diary materials on record, admittedly. It is found from the Caesar list.
Space 17.
There is recovery of 24
24.755.
24.47
755.
24.755 kgs of contraband substances within bracket ganja has been recovered from the possession of 2 persons. During the course of investigation, there is no recovery from the possession of this petitioner. The name of the petitioner is transferred from the statement of the co-accused persons. In view of the above, I am inclined to extend the benefit of anticipated gain.
Lordship, my objection can be noted, Lordship.
But I have one thing. But my brother was suffering from a liver cirrhosis and he was admitted in hospital. I have more kindly accommodate my method.
Which matter? There are other matters also. Now you leave. Where is he?
My brother was admitted in hospital, his liver transplant. Doctor advised that liver transplant is good.
Okay.
Like my late mother or my junior is there, not treated.
Okay. Condition meet the investigating officer once in a fortnight. And also, and shall appear before the court on the date fixed for appearance. Either condition. If are in failure to comply, the reference will go. It will have.
Grateful, Lordship.
Item 9, but for the appellants. Taken some time, Lordship, to the court.
CD is not available. CD is there?
No CD, no my lord, because they have not served a copy upon the state. They've been filed, affirmed and. That's
The
not
paper
that.
PO service is incomplete. Boxo is there. Boxo is there.
Yes, Lordship.
Boxo is there.
Lordship, I don't know because they have not served a copy upon the state, Lordship. That is the reason why. Lordship, let me take the case number, Lordship, I'll call for the CD, then.
Is Bornali Gupta is a practicing advocate of this court?
I've never seen her, Lordship. I think she's from Calcutta. Bornali Gupta.
None appears on behalf of the petitioner. For ends of justice, the matter is adjourned. Please this matter on 27. So, do you have? 27.
I can take.
Okay, ma'am. लिखा আছে item number निकुंज हो गए तो
Who is appearing? Arms Act.
Arms Act, Lordship. From the house of this accused, Lordship, it was seized, and from the.
What is his name? He has not joined. What is his name?
Nilendro Nath Narayan. Nilendro Narayan Rai.
But the talk. Ask him to join.
फोन पर ना चाहता
I can learn. No worries.
রাবার তো কোথায় গেল বলুন তো রেখে দিলাম কার এতে চলে গেল রাবার থাকলে দিন তো
দেখি
এটা কত none appears on behalf of the
State
petition.
is present.
You are for the state.
Yes. Along with sitting, page right.
Case diary is there.
Yes.
ওর মধ্যে আছে What are the sections?
My lord, 223, 221, 224, 212 and
One.
132 of BNS. Reduce section 3 of PDPP Act, my lord.
These are non-bailable offense.
Yes, my lord. Using a microphone loudly on odd night. Police requested them that they are
None
Letting the
appears on
stone up
behalf
the
of the
police.
petitioner.
and damage the police vehicle.
State is represented for ends of justice material. 27 তারিখ রাখ 27
I'm grateful to this.
আচ্ছা কি জয়েন করেছে নীলেন্দ্র ঠিক আছে পাশাপাশি ইয়ে
I have been for the state.
A case of 307
Malad.
All the petitioners are named in the 164 statement of the victim, specifically named. And role was also specifically mentioned. Filed in the vacation bench, my lord, but subsequently
move is found. Engineer.
I am holding the original case diary, my lord.
কালকে আসি not today তো
Yes, not today.
এই ওনাকে দিয়েছো নীলবাবু নীলবাবুকে কাগজটা দিয়েছো এই রেকর্ডটা জাগৃতি মিশ্রা মুভ করেছিল বললাম ওতে বাঞ্ছাপ একটা কাগজ আছে ওকে হ্যান্ড ওভার করে দেবে দিয়ে দাও চলে যাবে No. You're for the state?
Yes, no. I am for the
Not-
state.
এটা এ দেবেন নট টুডে মার্কিং করে দেবেন কালকে আসো
For another. 16 also, my lord, filed on 23rd September 2025, but they are not appearing.
ডেট দিয়ে কালকে রেখে দাও টুমরো ইট উইল বি
Hey,
No.
not pressed.
The advocate of the petitioner seeks that the petitioner does not intend to press this application.
একটা হয় একটা
Accordingly, application being CRMA 779 of 2025 stands dismissed, being not pressed. 15
15 মেগাট 14 নট টুডে হয়ে আছে নট টুডে হয়ে আছে 14 তো তখন যদি করবে তুমি
14 to দিন দাও। কাগজটা হ্যান্ড ওভার করুন, কাগজটা হ্যান্ড ওভার করুন, আমাকে দেখান যে হ্যান্ড ওভার করুন সিডির কাগজ এটা। Yes.
362 and 384 and 360 360 and 340 of the one Kobita. Yes, Kobita Gwala along with the fellow Sanjay Loha came to the house of the defense counsel and asked for Botaka Adan. Thereafter, defense came to know that this document was produced before the PF Provident Fund amount, Provident Fund office, and subsequently some withdrawal has been withdrawn. Provident Fund has been withdrawn in the name of defective complainant.
Provident fund amount has been withdrawn from the account of de facto complainant.
No, the Provident Fund amount withdraw of the defective complainant in the name of Kobita Kobita Gwa.
Kobita Guru is the complainant.
Now, complaint is the Vikas Vikram Gwala.
On behalf of special materials and along with Kobita Guru, I know for
This petitioner is the Radhipur named in the
PF
Yes,
account.
not anyhow related. Only because they are known to.
You know, 270, yes.
But the account was transferred by the kind paragraph 6, 6 and 7, my petition.
PC amount being transferred to the account of Kavita Koala and Atu. However, there is no person involved in some other person which have
And FIR was lost after 11 months of the alleged incident. The incident was took place on 7th October and FIR was lost in August 2025.
Yes.
Yes, my lord. There is a seizure witness bill at page 23 and 24. If you lost it.
Twenty-three. 23.
23 and 24 million. Using foreign country.
Where is the Caesar?
Caesar Miller at page 5. $500 fake Indian currency, 80 numbers,
Zakir Hussain.
mobile, কোনটা তোমার ইয়ে তো
No, no, this is a separate.
সাহেবগঞ্জ পুলিশ স্টেশন
No, no, this is separate one.
সরি
This is Birpara police. Birpara 133.
সরি সরি একটু ফরগিভ Milord, this is a case under section 316(2), 318(4), 338, 336, 340, subsection 2, and 3 subsection 5, Milord, within 5, Milord, that is 34, 406, 420, 467, 468, 471, ITC, corresponding section.
Page number?
Page number, Milord. Statement. Page 11, 13, Milord. And 11, 13, 12, and 15. By following the siphoning, the present petitioner, the total amount of rupees 5,57,170 from the PF office. Representing the wife of the present petitioner as we do.
Who is the complainant?
The from his PF account, the all amount has been withdrawn. Bikram Goala.
Now, Bikram Gwala is the complainant.
Yes, Milord.
He has been shown to be a dead person.
Yes, by showing his wife. His wife do not know what happened.
Kavita is the wife.
Yes.
Also, the advocate for the petitioner submits that there are no such specific allegations against the petitioner. The petitioner has been falsely implicated.
Milord, may I?
Since he
161 statement of Kavita is there, Milord, at page.
page
Milord, can I take back this? Is that in?
since
151 টা কোথায়? কবিতা
Kavita কোনো petitioner no.
the bank details. Kavita, page 44, Milord.
Falsely implicated.
And I have already folded the bank details. This is a statement of Kavita, 160.
Kavita is accused.
Yes.
Yes.
6 for grant of anticipated bail. Opposing such prayer for anticipated bail, learned advocate for the state submits that this petitioner making false representation before the PF authority has transferred a sum of rupees 5,57,337
1 second.
from the account of the complainant withdrawn gold transfer. Count of person. Physics for dismissal of the prayer for anticipatory bail. It is verification materials on record. It is from the statement of the witnesses that there are specific allegations against this petitioner of his involvement in transfer of amount from the PF account of the complainant, showing the complainant as dead. Further, it appears that an amount of rupees 270,113 was transferred to the account of Kobita Gwala on 14th October 2024 from the Employees Provident Fund account, and rupees 287,061. 287.
May I? Bank details, transaction details at page 32.
And
32 to 43. I have already folded.
Fourteenth October. And 287,061 on 19th October 2024. 14th and 19th. Consider above.
The wife of the
Consider above. And bearing in mind the nature and gravity of the offense, rejected.
I am grateful to.
amount has been transferred. Amount was transferred to the wife.
So, next.
I am grateful to.
Yes. 8 নয় 8 হবে হ্যাঁ এটা রেকর্ডে থাকবে এইটা ওটা হ্যান্ড ওভার করবে
I think 16. There. I think 16. I want to the mission on the no, I start to the victim.
Affidavit of service filed on behalf of the petitioner is taken on record. It is found that service has not been effected upon the de facto complainant victim. In view of the above, state is sir, a copy of it. State service. 27th
27 possible minute.
27 তারিখে তো।
না,
This is matter 27. এটা document affidavit service not affected, huh? Next.
Item 17.
হচ্ছে কি?
একটা করে কপি দিবি।
What is 69?
Promise to marriage and 323 506.
Same order করুন 27 তারিখ 27th.
Malad.
হুম?
Item 18. Oh, item 18, I have instruction to not to read that.
How many times? How many times not press?
First time.
Attempt to murder, man, of 27.
Move this application, why not press? What is the injury?
Injury. Losing injury, so page 31.
Now, the advocate for the petitioner submits that the petitioner does not intend to press this application. Dismissed as being not pressed.
Item 19.
20 টা হাতে নিয়ে রাখুন।
14 C of the foreigner sector. Indian 14 C you should have existing another point is
Yes.
My lord, say it. My lord, already charge sheet submitted, charge sheet in page number 42.
What is his statement? What is his name? Omar.
My lord, kindly see the page 26, 27, 20, 22, 161.
Let me advocate for the petitioner submits that the petitioner is a Indian citizen, and there are no such allegations against the petitioner. He seeks for anticipatory grant of anticipatory in favor of the petitioner. Opposing such prayer for anticipatory and an advocate for the state submits that this petitioner gave shelter to a Bangladeshi national. He seeks for dismissal of the prayer for anticipatory bail. It is found from there is a case in materials and record, and from the statement of the witness that there are allegations against this petitioner of giving shelter to a Bangladeshi national, and he also fled away from the scene of occurrence during raid. Considering such rejected. Next. No bill payment paid. He didn't go back to the court.
No, my lord, my prayer was turned down. Fill the charge sheet also, my lord. There is no provisional assessment, my lord.
What is the total amount?
But there is no quantum. In the FIR charge sheet also no quantum from the airport, my lord. But it is not given
What is there?
amount. Quantum.
Rejected by the OPSO court. There are allegations of lunging this very unauthorized manner. The case is.
Yes, theft 0.8 kilowatt of electricity. That
Cooking.
amounts to 22,875. Assessment is there.
FIR charge sheet. Next one, my lord.
What?
But in the FIR there will be that.
There is allegation of hooking.
Hooking is there.
So how will they do it?
Yes, Lordship.
How
You
will
were
they
served
assess it? You are
35-3
not,
notice.
it is not non-payment of the electricity charges.
Yes, he
It's
was-
of
yes.
pilferage.
Yes, pilferage.
The advocate for the petitioner submits that there is no provisional assessment of the electricity. He seeks for grant of. He seeks for grant of anticipatory bail.
Lordship, he was served 35-3 notice. He did not comply.
Learned advocate for the opposing such prayer for anticipatory, learned advocate for the state submits that this is a case of pilferage. Taking. Wait.
In the FIR last time.
Information.
Information.
ठीक है, manner, unauthorized manner. Gulal, by direct hooking. It is found from the nearest. It is it equivalent? 6 for. 6 for.
It is land liable of the state.
Sum is that pilferage. Stop. The petitioner has not complied. The notice under section 35(3) of the BNSS Act.
Page 13 is the notice, Lordship.
Page
13, 1-3.
It is found. It is found that the petitioner, there is allegations of petition against the petitioner of enjoying नाम की दूल्हा लालन by direct hooking from the nearest LTOH line. LT capital LTOH line. Such service was disconnected. In view of the above, considering such materials and the gravity rejected. Okay. Next.
I think 21.
Not today.
You are for the statement.
You are in 21? Who is for the state?
What I first.
What is this thing? Charge sheet has been submitted. Has been absconded.
No, on the basis of statement of tax sheet submitted.
Yes.
Coercive statement more.
Level application for the petitioner. What is the submission?
Was co-accused statement, confessional statement. Page number 32.
He fled away from the scene of occurrence. He fled.
No, ma'am. My lord, 15 onwards, 15 to 18.
What is your name?
My lord, his name is, my lord, Roshidul Mia.
Now, where is the statement of the co-accused?
My lord, your lordship peruse, my lord, page 15, my lord.
15.
15 onwards, my lord, 15 to 18.
2 persons have been arrested.
Yes, my lord.
What is their name? The other accused person? Dui Bhakti.
The other accused person, my lord. Mojirul Haq.
Majirul.
Irshad Mia. My lord, it will be more specific, my lord, page 32 and 33.
How many recovered? Two. How many fake notes were recovered? Two.
Well, the amount is below 4,000.
Learned advocate for the petitioner submits that he is not named in the FIR. The name of the petitioner is transferred from the statement of the co-accused. There are no such recovery from the possession of this petitioner during the course of investigation. He seeks for, sorry, upon completion of investigation, charge sheet has been submitted. He seeks for grant of anticipatory bail in favor of the petitioner. Then the advocate for the state opposes such prayer. Here is the case that the materials and record. It is found that he was FIR it is found that the petitioner was not named in the FIR. Two persons were apprehended on the date of incident, from whom two notes, currency notes of denomination of rupees 2,000 each was recovered. The name of this petitioner is transferred from the statement of the co-accused. During the course of investigation, there is no such recovery from this petitioner. Upon completion of investigation, charge sheet has already been submitted. Charge sheet. Yes, Raj. Charge sheet has been submitted against the petitioner and two others under section 489B and 489C of the IPC. Concerning the above, I am inclined to extend the benefit of anticipated bail to the petitioners. Allowed. Condition, condition 430 to appear before the court on each date of fixed for appearance and shall also meet the inspector in charge of the, which police station is this?
Mekliganj.
Mekliganj police station. Fortnight, huh? Until further order. Next.
This is a very unfortunate incident that the petitioner number one is the husband of the deceased lady. And then she committed suicide. For last 2 years, she was not keeping well, and she was getting treatment. The hospital at Jalpaiguri is in page number 11, Lordship. 9 years of marriage, Lordship. Page number 11 is the medical document.
What is the case?
She committed suicide, Lordship. My wife committed suicide. 9 years of marriage, Lordship.
The petitioners are the husband.
Petitioner number one is the husband.
Father, mother, brother-in-law. Yes.
My lord, case diary only few pages, my lord.
Why?
Case is of, my lord, no, not yet, my lord. Case was initiated on 12th of October 2025.
12th October.
Yes, my lord. About 1 month and few days, my lord. 161 statements are there, my lord. Page 4, 5, and 6.
The postmortem report is not.
Postmortem is also not collected. Admittedly, suicide by the
Postmortem.
161 statement of the sister, mother, and father of the victim.
Produce the postmortem report.
Malad.
State is directed to produce the postmortem report along with the case diary on the returnable date. Accordingly, it is found that the postmortem report has not been collected as yet by the investigating agency. State is directed to collect that and place it. Okay, State is directed to collect the postmortem report of the deceased and place the same in the case diary on the returnable date. Which this matter on 27th.
Malad, right. Postmortem report.
তিনটে নাম দিয়ে তিনটে
24 টা ready রাখুন। One 98, 306.
No, 307, 109, 307, and 326. My allegation of.
Who are these persons?
Petition number 1 is the husband, petition number 2 is the father.
Brother.
Brother-in-law.
Brother-in-law.
Brother-in-law, matrimonial dispute, no such injury, and she said earlier thereafter lost complaint, no such injury.
Only one injury report.
Only one injury report.
Learned advocate for the petitioner submits that the FIR is the result of some family disputes. There are no such notable injuries sustained by the complainant. The petitioner number 1 is the husband, and the petitioner number 2 is the brother-in-law. There are no specific allegations against the petitioners. He seeks for grant of anticipatory charge sheet submitted.
Charge sheet submitted.
Charge sheet upon completion of investigation, charge sheet has been submitted. He seeks for grant of anticipatory bail to the petitioner. Where are the statements?
Statements, Lordship.
Yes.
Statement of the
Ruxana.
7, page number 7.
Opposing such prayer for anticipatory advocates for the state submits that there are specific allegations against these petitioners who are the husband and brother-in-law respectively. He seeks for dismissal of the application for grant of anticipatory bail of the petitioners. Here is the case that the materials on record. The allegations as revealed from the statement of the witnesses are general in nature. The injury report shows that there are no visible external injuries. the petitioner at the time of examination was pregnant within bracket 8 months. Thank you. 8 months bracket. Considering the above, inclined to extend the benefit of anticipatory bail in favor of the petitioner. Hello. Later we meet. The organi will attend the vote on each and every charge sheet submitted, no?
Charge is submitted on 10/5/25.
ওই এখন comprehensive charge sheet has already been submitted 9টা add করেছি Where is the copy of the charge sheet?
Copy of the last charge sheet is at the last page, Lordship. Page 39.
39.
Yes, page 39 of the case, right, Lordship.
Huh. Rashi. Hello. Why are you attending the court? Attend the court? Attend the court. In the event of failure of review.
In the next survey.
But I have been instructed to appear on behalf of the defense of
But why am I praying for an atonement? It is the defective of that preferred a writ application complaining that police inaction in this matter. Ultimately, we appeared and we placed our submission. And our submission was that on or about the date of incident, time of the alleged incident, I was not there. I was posted in Prime Minister's security duty at that particular point of time, and I have annexed my command certificate and the detailed statement of the officers' official documents I have filed, and that part has not been investigated. During the hearing in the writ petition matter, I presented these facts to the court, and the IO has been changed with the direction for free and fair investigation matter. During the pendency of this has happened matter. Now, until that aspect is investigated into properly matter, this should be a futile exercise. That is why I am praying for next circuit. Here is the order. I am praying for next circuit until this part is investigated. Otherwise, there will be a denial of justice. Because this particular investigation is not contained in the present CD, naturally, my lord. This has been brought. What do you mean? Okay, my submission. Even I considered the proposal of free and fair investigation.
Withdraw this application, liberty to file application.
Wait a
What is the use
minute.
of
Free and adjournment, let the fresh CD come with the development. Filing an application, withdrawal, my lord, it's a long process. It
Why?
is easily disposed of during the next circuit, my lord.
He's trying to bring everything.
Otherwise, my lord, this is very clear, the order is clear, there will be a denial of justice. Wait a minute, madam, I get something. It is a question of my department. Let the investigation take place. Next circuit we will bring.
When was the application filed and when is the writ petition filed?
27th October.
27th of October. And writ petition was filed subsequently during the pendency. This application has been mentioned in the writ application. That is why also I am praying for an adjournment in the next circuit. And I didn't take a single adjournment. It did not reach. The list was very heavy. It did not reach, despite the fact that I mentioned it for here. And now there is a
Wait,
substantial change. This
the
part is
respondent because the complaint for the respondent because they are not taken effective.
since I claimed an alibi.
Multiple views were verified.
My lord, he is trying to bring us a face thing, lordship. So lordship, my lord has rightly if this application is withdrawn, that will not be right, lordship. That
And
will
carry out English in accordance, you can endeavor to.
it's not pressed.
No, we not of this.
No, as of now, whatever the materials available in the case diary,
Well,
that will be looked into by the court in the pending application.
here lies the problem, madam. The problem is that the particular, since I have taken an alibi, I have submitted the Xerox copies of the document. An alibi is a past and defense, but the proof of alibi entirely depends upon me. At this stage, if I want to, unless this particular aspect is investigated into, my lord, I won't be able to substantiate my claim with a Xerox copy only.
But
madam.
this,
That is why
this
it is
order
my
was
lord.
passed at the instance of the complainant.
No, my lord, I consider to it.
This writ petition was filed at,
My lord,
Mr. Biswas, I can see the cause title. The writ petition was filed being agreed by the nature of investigation undertaken by the investigating agency.
My submission there.
After, whatever, let me finish, then you, all is on record. So after that, the court has directed that you change the, give a competent officer to investigate the matter.
My lord, no, my lord, may I point out one-
Investigate the entire aspect.
My lord,
If you say that you have an alibi that on the date of incident you were posted in the Prime Minister's security, then you can produce documents to that effect.
I have produced the document.
Where is that? What is?
Still now,
No, I'm not absconding, or I'm government law holder.
let my lord.
No, is there any abscond, any,
Several material that he was present at the time and he was duty.
No, please don't mislead the court, madam.
No,
You are misleading. I'm pursuing a legal remedy.
he has not corrected his.
I'm pursuing a legal remedy, my lord.
What is in the case diary after 3rd November?
My lord, this is the certified copy.
3rd November, I think,
No, there is no reflection. The last page is 8 October 2025. This is the certified copy. Original
So
CD is
this-
the
Sir,
investigation officer. My lord.
in the writ petition, the state was represented. He has submitted before the court that since he was posted in the security of Honorable Prime Minister, he was not available.
My lord, this is the
Upon that, the investigation was.
Yes, my lord.
Now, what happened after 3rd
My
November?
lord, this is the certified copy. It is and the original CD is with the investigation officer.
No. So let's see in the case diary whether there is any investigation to that effect or not. Let the matter be placed on 27th. Let him come with all the records after 3rd November. Thereafter, we'll decide whether to post it.
That can be, if this aspect has
On
already
the-
investigated into it.
Then
they
we'll
are-
on
Well, he'll be-
on the prayer of learned advocate for the petitioner, list this matter on 27th.
Let it get to the order.
Place this order. I just find out from the case diary what investigation was undertaken after 3rd November. এখন দিয়ে দিন 27 তারিখে দেখি চলো
But item now 134 to 36 has been upgraded, my lord, and the matter will be taken up at 3 p.m. But possibly there is a 3:30 again today, my lord. My lord, is there any possibility the matter be taken up earlier, my lord, or at 3?
Not at 3. 3 p.m. there is another matter under motion.
My lord, Mr. Mukherjee and Mr. Owen Bhattacharjee will appear.
He mentioned that matter.
If any
35 to?
134.
But the affidavits are ready.
Well, these are motions. First time.
These are those matters in
Yes,
which
ma'am. Mentioned by.
But you have-
Yesterday.
you have filed the affidavits.
But these are the first time. Motion stage. Motion matter.
No, there were other matters. 7 to 8 matters.
Those are other matters.
Those are the matters. Then we'll see. Tomorrow we'll see. What is the urgency?
134, 36, 236.
134 and 136.
134, 35, 36.
The motion matters. So, करके देखो. Tomorrow. Tomorrow, see afterwards. We'll call the list tomorrow. Sure.
I think 25.
I'm for the state lordship.
There's some other words, lots of welfare assistance by there's a 200, 300 people gathered, there is a group criminality in the area, and police personnel came to stop them. People were arrested, madam, and communal tension, even madam, most of the people in the but madam, 5%, madam, granted anticipated, madam, is 16.
Charge sheet submitted.
Charge sheet pending lordship.
And poverty.
Injury report simple lordship. There are lordship 4 injury report. 4 injury report are
So
simple.
they are named in the FIR. Have you checked?
Total 34 accused lordship.
Madam.
And they mean the
So these
all
8
are,
persons are named in the big
yes,
number.
lordship. All
What
are
is
the
the
name in
serial
the
number in the
FIR.
FIR? Number 1 serial number.
Serial number as per FIR lordship, petitioner number 1, serial number 5, petitioner number 2, serial number 8, petition number 3, serial number 14, petition number 4, 11, petition number 5, 9, petition number 6, 4, petition number 7, 18, and petition number 8 which is 7. All are FIR name.
Learned advocate for the petitioner. Case diary
Yes.
submits that on the date of incident, a group of 240/300 mob made an agitation there are no such specific allegations against this petitioner. Stop. The co-accused persons have been granted anticipatory bail by this court. He seeks for grant of anticipatory bail in favor of the petitioners. The advocate for the state opposing such prayers submits that these petitioners were part of unruly mob causing injury to the police personnel. He seeks for dismissal of the application for grant of anticipatory bail of the petitioner.
One eyewitness is there, lordship, page 11.
Here is the case materials on record. It is found that on the date of incident, there was certain agitation resulting in injury to the police personnel. The nature of full stop, the nature of injury is simple. Further, this court in CRMA 546 of 2025 has granted anticipatory bail in favor of the co-accused. And 164 statement?
No 164 statement, 161 statement, lordship, as they are, lordship. 10, 11, 13, and 14.
Considering above, I am inclined to extend the benefit of anticipatory bail in favor of the petitioners. What was allowed? The petitioner shall report to the investigating officer once in a fortnight until further orders, and shall appear before the jurisdictional court on each day fixed for appearance. In the event of default in appearance, the jurisdictional court shall be at liberty to take appropriate steps to secure the presence of the petitioners, including cancellation of anticipated bail granted hearing without further reference to this court. Allowed.
Get closed.
Item 26.
Before the state.
Kindly be not to him. Mr. Arjun Chaudhary is not present in this.
You are for the state?
Mr. Arjun Chaudhary is just in this.
Not today.
I'm grateful.
27.
Yes, madam.
Up to the victim, which was taken.
27th. Affidavit is always filed on behalf of the petitioner taken on record. It is found that service has been effected upon the de facto complaint victim. However, the same has made in English language. State is directed to serve. Which police station is this? 27th.
Twenty-eight.
Why? Why not today? State is there. 132. What is the difference today and tomorrow? No documents if required. What is the case?
I suffered
As a result, effect of receive injury on person. His diary is here.
His diary with Mr. Abhijit Sudha. He is left for his personal.
He has left the court.
Yes, sir.
Because not
to them. I'm grateful to them.
Not to.
29.
Mr. Saurabh Ganguly of the state is engaged in court number.
Pass over. Ask him. Pass over. Not particularly people. Tomorrow.
Tomorrow.
Next.
Thirty.
30. হয়েছে কি আসেনি তো
108
আমরা তা হয়নি সেটা মার্ক প্রেস হয়েছে ডিফেক্টর 2 for the state lordship petitioner lordship I don't know Mr. Karti abatement to suicide antemortem hanging lordship she was compelled to hang common intention of several persons 161
where is the petitioner has not come not today no date দিচ্ছেন তো দেখেন আজকে not today এটা not today করো not today
31.
31
Husband, mother-in-law, applicable statistics is quite I also specifically stated in my character section of my application, friend is also
this Mohammed Samsad is husband and 2
Who is the mother-in-law?
3 is the mother-in-law what is in the case diary
yes the case diary is here with me yes there are no pages lordship I'm just folding the 161 statements
85 is corresponding to which section
190.
and 109 7
yes
3 5 any injury report
no injury that's it
Then I advocate for the petitioner submits that the victim is presently the matter has been amicably settled between the parties and the victim is presently residing along with the petitioners in the matrimonial home. There are no such specific allegations. We seek for grant of anticipatory bail in favor of the petitioners. Charge sheet submitted.
that's it submitted lordship
Upon completion investigation, charge sheet has already been submitted. One, two, three. Yes, madam.
Hello, I'm the department of she is pregnant and started residing with her.
Then the advocate for the state opposes such prayer for bail for anticipatory bail and submits that opposing করে দিন and about the opposing the prayer for anticipatory bail submits that there are allegations against the petitioner of assaulting and torturing the victim in the matrimonial home. Victim lady করে দেন he seeks for dismissal of the application for grant of anticipatory bail. Then it advocate for the de facto complainant concedes that presently the victim lady is residing in the matrimonial home. He leaves the matter to the discretion of the court. Here is the case in the materials on record. The statement of the witnesses. It appears from the, but it is found from the statement of the witnesses recorded under section 161 of the CRPC that the allegations are general in nature. There are no such injury reports. Stop. Consider the above. I am inclined to extend the benefit of anticipated bail. Upon completion, charge sheet has been submitted. We extend the benefit of anticipated bail in favor of the petitioner. Allowed. ওনার সাবমিশনে বলে দিন তো যে petition number 1 is the husband and petition number 2 and 3 are the parents-in-laws. কোনো সাবমিশন পিটিশনের সাবমিশনে একটা জায়গায় ঢুকিয়ে দেবো। Next On the prayer of learned advocate for the petitioner, raise this matter before the next available circuit court.
She doesn't hide and no necessarily information is needed. The fact that he was included in this matter.
He was not named in the affair. He was not named in the affair.
Please mention, but he was not at the spot of this occurrence, and on the basis of the prior assumption, he was included in this matter.
Other co-accused are on bail. Charge sheet has been submitted. Then the advocate for the petitioner submits that the petitioner has been falsely implicated in the instant case out of mere suspicion. Upon completion of investigation, charge sheet has been submitted. The other co-accused are on bail.
My lord, I am for the state.
Co-accused.
My lord, in the petition, the PS case number and the PS name of the PS has been wrongly written, which is why we are not able to produce the CD. We have reported a mismatch. We have obtained a mismatch report already, my lord. It's like with the office. Right? কোন থানা তোমার অ্যাকচুয়ালি এটা? কুচলিবাড়ি, তুমি পিটিশনে কি করেছো থানা? হ্যাঁ, কুচলিবাড়ি and Mecklenburg two distinct different police stations, my lord.
Kuchbihar and Mecklenburg are separate.
No, Kuchlibaड़ी is a separate police station, man. Mecklenburg comes first. Kuchbihar district starts from this side, Holdibari, then Mecklenburg, then Kuchlibaड़ी comes.
Then
Different police station. You are not correctly written the cause title.
Equal with it. On the prayer of learned advocate for the petitioner, leave is granted to correct the police station case number in the cause title as well as in the prayer portion of the application. Release this matter on 27th.
Look. Obliged, Lordship.
Article 34. I'm on the state papers.
Yes. Maqbool. 329 is?
Can you consider we are neighbor, they have long-standing enmity for his responsibility.
So injury report, my lord, page 66, 67 and 66 and 67. Blunt injury, my lord, the nature of injury is simple. But head injury is there. Charge sheet submitted, my lord.
Okay. Gauri Roy.
Next date 2nd January 2026 for hearing. One 61 statement of two victims is there. 58 and 63. Page.
Noor Bucks or Maqbool? Awesome. Then the advocate for the petitioner submits that the Mohammed Noor Bucks. Noor Bucks or Maqbool. Submits that there is long-standing disputes between the family members of the complainant and the petitioners. There are no such specific allegations. He seeks for grant of anticipatory bail in favor of the petitioners. Okay. Opposing such prayer for grant of anticipatory, then an advocate for the state submits that the victim sustained head injuries and there are allegations against the petitioner of their involvement in the alleged offense. Here is the case and materials on record. It is found that these petitioners, along with others, assaulted the victim. Be that as it may, the nature of injury, as is revealed from the injury report, is simple, and the victims have been discharged after 1 day. Discharged from hospital after 1 day. Considering the above, I am inclined to extend the benefit upon completion of charge sheet has been submitted.
Yes,
Allowed.
I'm grateful.
And for this chairperson.
Which case? What are the sections?
Sections are.
Those should be NDPS.
C 25 and 29 of the NDPS Act. But the recovery, the contraband was recovered not from one Latif Mir, who was arrested and at present he is in custody. Now, my lord, I am Muhammad Mir. My lord, kindly turns to page 8 of my application, my lord.
Yes.
My lord is found it. My lord, 8th para, it starts from on preliminary interrogation.
Nothing revealed that he along with
Lord is
with
found it.
illegal cough syrup. Latif Mia's brewed the cough syrup in his house. Smuggled them. Yes.
Look, it says, my lord, on preliminary interrogation, Latif Mia revealed that he, along with one Muhammad Mia of Balapukuri.
Yes.
This is the only allegation. Other than this, my lord, there is nothing against me.
This is the case where evoluminous, but half of it is photographs of inventory. Kindly says, Lordship, I am referring the pages. Page 14 is the Caesar list. Kindly says page 14, Caesar list.
How many?
Caesar list from Latif Mia's house. Kindly says the place of Caesar at the top.
Yes.
House of Latif Mia. Latif Mia was arrested and on interrogation he disclosed the name of this petitioner under Section 67 NDPS Act. FSL report has been collected, Lordship, page 99, says codeine. 12,000 bottles. And Lordship, page 23, page kindly says page 23.
That is the 23, Lordship.
Yes.
That is the statement of the accused. On interrogation, he stated this.
Charge sheet submitted.
No, Lordship.
Advocate for the petitioner submits that the name of the petitioner has transferred from the statement of the co-accused. There is no recovery from the possession of the petitioner. He seeks for grant of anticipatory bail in favor of the petitioner. And advocate for the state opposes such prayer for grant of anticipatory bail. However, he concedes that the name of the petitioner has transferred from the statement of the co-accused. It is accused of the materials on he seeks for dismissal of the application for grant of anticipatory bail. It is accused of the materials on record. It is found that the name of the petitioner is transferred from the statement of the co-accused. There has been seizure of 12,000
bottles.
12,000 bottles
From the house of Latif Mia.
codeine phosphate from the house of one Latif Mia, co-accused. There is no such recovery from the petitioner. In view of the above, allowed.
Grateful, Lordship. Hello.
I need the investigating officer. NDPS হলে অ্যালার্ট হয়ে যাবেন সব জায়গায় যেন প্রত্যেকটা জায়গায় থাকে আপনার যে appearance in the court on the date fix সবগুলো দিয়ে দেবেন ঠিক আছে in the failure ওখানে না গেলে তো ট্রায়াল হবে না $36 36 simple কিন্তু on the prayer of learned advocate for the petitioner let the matter appear before the next available circuit bench 36 হয়ে গেল 37
to 39. 39.
36 39 same order করে দিন 36 to 39 same order করে দিন no this is 38 টা কার আছে 38 আনন্দ পাল this is not সুদীপ গুহ 38 39 চলো ঠিক আছে next which one which item 40 not called as it wait
40.
yes
Mr. Subhashish Mishra for the statement. He is engaged in the court number.
CD has come CD has come
I don't know.
need one
But password I can do.
yes.
Lincoln.
Gautam পাসওয়ার্ড রাখ দেখি আছে কি ওয়েট নেক্সট এটা পাসওয়ার্ড রাখ চেঞ্জ
41.
সেম অর্ডার
My lord, 42, I beg appear under the petitioner, my lord.
Yes.
My lord, the incident, the allegation which was stated in the complaint is almost about a year ago. The petitioner made the de facto complainant in a bank for the purpose of loan. Both are major. Thereafter, on repeated occasions, state
Service. Service report.
No, there is a service, I gather. And it has also been served, my lord.
Affidavit of service filed on behalf of the petitioners. Who is for the state? Affidavit of service filed on behalf of the petitioner is taken on record.
Shoika Chatterjee and Chotu.
It is found that
My lord.
is direct deposit, local holiday. Is it delivered?
My lord, may I continue?
Actually, it is found that service has not been effected upon the de facto complainant victim. State is directed to effect service and file service report on the returnable date. Which police station is this? 27th.
Obliged, my lord.
We open the affidavit of service. 27th.
27th, my lord. Obliged, my lord.
42, 43, 43.
Say what the next service. Hmm?
44 I'm for the state.
তো অনেক ফাইল
Worship,
You are
Mr. Go, yes, Mr. Go's mom.
No. Next.
Yes.
You think? Who is for the state in 45?
45 Mr. Anuruddha Biswas is there, na?
Yes.
Anuruddha koi? CD de? For which? Case diary is with me, Lordship. It is under 103 and yes, it. What?
His diary has come.
Yes, yes, yes. Case diary is with me. কি মানে এটা কি রে?
Not today.
এই সেকশনটা কি আছে? 103
Not today. কালকে আসবে।
দেখবি তো তুই।
Tomorrow.
Tomorrow. বাবা আমাকে দে তুই তো কেউ না। কত নম্বর আছে? 46 কি আছে? 46. Yes, my lord can start.
8 and subsection 5 of the BNS, your lordship. The present petitions are not the principal accused, your lordship. Could I continue, your lordship?
Not possible, Lordship. I'm calling them. Bhaskar Das is there.
In that case, your lordship, kind of faces matter tomorrow, we will have a fixed and court as well, your lordship.
Who is for the state?
Mr. Bhaskar Das.
Mr. Bhaskar Das.
Your lordship, the allegation is very omnibus in nature, your lordship. The present petitioners are not the principal accused, your lordship. So the allegation is that it is that the principal accused had given his motorcycle for repair to the shop of the deceased son of the de facto complainant. And subsequently, when it was not returned on time, he, along with the present petitioner, threatened him. And subsequently, the victim, your lordship, the son of the de facto complainant, committed suicide. Out of shame and fear, because he couldn't repair it and couldn't return it back within time. So, because of that, your lordship, he had committed suicide and that come to death, your lordship. But the involvement of the present petitioner is that only that they were present at the time of that altercation, your lordship. The FIR, the written complaint is at page 10 of my present petition, your lordship. And there is no such complaint against the present petitioner's involvement, your lordship. The written complaint is at page 10, your lordship. They were only accompanying the principal accused whose motorcycle was there lying with the deceased son of the de facto.
Yes.
নোটিংটা দেখে দেখে যাবেন নোটিংটা গেছে টিম রিপোর্ট আছে এটা চার্জশিট হয়ে গেছে
Rahul is the principal accused. Rahul.
Yes, your lordship. He is not present before the honorable court, your lordship. Present petitioners are already there.
না লিখে
Charge sheet has already been submitted, your lordship. So no other.
Very much.
What is there in the case?
পিটিশনের দুজন সঞ্জিত বিশ্বাস
Postmortem report?
Yes,
29.
29 page.
Death due to effect of hanging.
Ashu. The advocate for the petitioner submits that there are no some direct allegations against the petitioner. Over an dispute over repairing of a motorcycle over dispute with regard to repairing of a motorcycle, the allegations of threatening has been made, which is precisely against the principal accused. The petitioner only accompanied the principal accused to the house of the victim on the date of incident. Charge sheet submitted?
Yes,
Upon completion, the charge sheet has been submitted. She seeks for grant of anticipated in favor of the petitioner. Learned advocate for the state opposes such prayer. Here is the case diary, the materials on record. It is found from the statement of the witnesses recorded under section 160 of the CRPC that these petitioners accompanied the principal accused to the house of the victim. There are no such specific allegations against the petitioners. The victim died due to effects of hanging, antemortem in nature. Considering the above, I am inclined to extend the benefit of anticipated upon completion of charge sheet has been submitted. Charge sheet.
On 28th August 2025, Your Lordship.
Konok. Sanjeev. Extend the benefit allowed. Whether the meet the investigating inspector in charge once in a fortnight until further orders. In default, cancel করবে ওটা লিখে দেবে। Thank you, Anand. Not to next.
48.
State.
Allegation under section 105 and 300, subsection 5 of the in this Lordship. Lordship, from the reducer of the FIR, Lordship, we can found that Lordship, no direct allegation has been made out against this present petitioner's Lordship. The allegation is that Lordship on 27th of March 2025, Lordship, some person called the victim and who they are saying that they are written in a group, Lordship, and on 12th of April 2025, Lordship, the victim was found injured nearby his home, which is around 200 meters from his home, Lordship, and he was rescued and he was shifted to hospital, Lordship. And subsequently on 14th of April, he was diagnosed. Lordship, this is the entire incident, Lordship. Lordship, accordingly, allegation has been made against the 4 accused persons, Lordship. And against this, the present petitioner, no direct allegation has been made, Lordship. Lordship, it is also fact that there is a delay of lodging FIR, Lordship. That is around 37 days. And two accused person already granted bail by the landed trial.
Trial's not started, how can the trial court grant him bail? The trial has not been started, the investigation has not been completed yet. Which court has granted bail? Jalpaiguri is a court where the trial takes place.
JC, so the video there. Yes.
My lord, there is the investigation is in the midway, my lord. May I hand up the CD, my lord? Page 59 is the post-mortem report, first of all, my lord. There are a series of injuries mentioned in the injury column, my lord. These are fresh injuries. 59, my lord. I have marked it.
Yes.
There are a good number of injuries, like fatal injuries are there. Now, thereafter, my lord, I would like to invite your lordship's attention to page number 16 and 17, my lord. I have marked those pages also. His name appears in the group of people who actually called him out, and thereafter he was last seen, the victim was last seen with them, my lord, last seen alive with them. And subsequent thereto, the investigation is going on, my lord, and this is an anticipatory bail application. In this case, my lord, the nature of the case is based on circumstantial evidence. Thereafter, and the last scene, my lord, thereafter, the custodial interrogation is essential for determination of the ultimate issue, my lord. So at this stage, if anticipatory bail is granted, they will definitely go scot-free, my lord. The investigation will be seriously prejudiced.
The
Lordship. Lordship, may I
deceased, no, death of the deceased. The body of the deceased was found 200 meters away from the body of the deceased was found 200 meters away from the place where the kirtan was going on.
Lordship, some points need
No,
to be
sir.
clarified,
Yeah.
Lordship.
There are no direct allegations against the present petitioners. The co-accused have been granted bail by the learned sessions judge. He seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, learned advocate for the state submit that
Specify the dates, Lordship.
submit that okay, बोलूँगा, there is delay of 37 days in lodgement of the FIR. ঠিক আছে?
27th of March, he was born. And 20th of
should we do it?
April, he was found. No time declaration has been recorded, Lordship. He was admitted 2 days in the hospital, but no declaration has been
His
recorded.
condition might not be so. He might not be in a conscious state. That is why thorough investigation is required, and which is why a custodial interrogation is necessary, madam.
Advocate opposing such prayer for anticipatory bail, and an advocate for the state submits that the deceased left with these petitioners and 2 others, and subsequently his body was found. He was taken to the hospital.
Subsequently, my lord, by the
He was
family
found.
members.
Sir, if you do like this, I cannot dictate the order. I'm asking him, clarifying from him what is the position. Now, from that, you take a cue and start your submissions again, then I can dictate. If you have finished, then I will dictate the order. Every time if you intervene,
Investigation is just an embryo at this embryo, my lord, needs to be developed.
the body, the victim was found in an injured condition, 200 meters from the house. Subsequently, the victim succumbed to his injuries. मेरे पास submission है कुछ ना? He seeks for the PM report would reveal that there are sufficient injuries on the person of the victim. Here is the case materials on record. The statement of the witnesses shows that the victim left with these petitioners and 2 others. And he was left in indisposed condition about 200 meters away from the house of the victim. The house of the petitioner. The postmortem report shows that the death was due to intracerebral injury within left cortex of brain, sufficient to cause unconsciousness with subsequent death and is antemortem in nature. The date is few minutes after the injury. Considering the aforesaid materials and bearing in mind nature and gravity of rejected.
Problem.
নামটা
তিনটে আইটেমটা দিন তো তিনটের সময় যেটা আছে তিনটেরটা কি হবে? কেন বলো? ও আচ্ছা আচ্ছা, there are no ingredients. না তিনটে মোশনের আইটেমটা দিন। এটা কি রাখবো? তো কালকে ওপরের দিকে রাখো। কালকে ওপরের দিকে রাখো, না মোশনের আইটেমটা তিনটে সময় বলে দিলাম, ওটাকে টেক আপ করে নি। What is your name, sir? You are Mr.
Singhal.
Mr. Singhal, I take this matter tomorrow at the top. Okay? এটাকে তুমি ওপরের দিকে রাখো।
Then interim order that is being expired
On 30th?
Till Friday to
Within this period, we heard. I have heard you. You have placed certain judgments.
And I just wanted to.
They are
my
the
lord, I have
in-laws.
followed the CD.
They are in-laws.
My lord, yes.
I've got the CD, man.
Tomorrow, এটাকে উপরে রাখো, কালকে করব।
Defect is also placed. I'm got the defect.
Tomorrow, এটাকে উপরে দিকে রাখো।
I'm late by 1:35 and 1:37. I'm late by Mr. S.N. Mukherjee and the senior counsel, but he is there online. Well, want me to decide the fate of other two applications? Your lordship need not open other two bids. But till such time, Mr. Mukherjee joins for it. If I may just give the bird's eye view of the case. But the de facto complainant is a business lady. She had an agreement, financing agreement with the company of the petitioner. Petitioner is an office bearer in item 134, 135 another, 136 another, same FI. Now, loan was accommodated. Admittedly, she defaulted in repayment. That's admitted in FI. I'm not taking your lordship to any additional fact which is beyond FI. My lord, 2019 was the first agreement. Then, my lord,
No, this
loan
is
report
carrying on which
notice-
business?
I'm sorry.
What is the business?
But the business was, my lord, he was into construction. He purchased, my lord, there is a loan come hypothecation, my lord, Mr. Mukherjee has joined.
May it please your lordship, my lord. My lord, very shortly put, my lord, this is an case where in effect, my lord, a completely civil dispute which has been adjudicated upon. After adjudication, my lord, has been converted, my lord, into, my lord, a criminal proceeding. My lord, may I just give 4 facts to your lordships? My lord, the 2 loan agreements here were for purchase of, my lord, certain equipments, my lord, which are used, my lord, for, my lord, construction activities by, my lord, the complainant. Loans were taken, equipments were hypothecated, there was a schedule for repayment. That repayments, my lord, were not made. Therefore, my lord, in accordance with the arbitration clause contained in the agreement, the matter was referred to arbitration. In spite of notice, the complainant did not appear, my lord, in the arbitration proceedings. an award was passed. Award provided for payment of money, as well as, my lord, specifically declared that we were entitled to take, my lord, possession of the hypothecated machinery and, my lord, deal with them. My lord, no payment was made pursuant to the award. My lord, we took possession with notice. We then, my lord, gave a pre-sale notice. My lord, again, my lord, there was, my lord, no response to that. My lord, we sold, my lord, equipment, realized money, and my lord gave a post-sale notice saying that a particular amount still remains unrealized. Now, my lord, what happens now is, my lord, after, my lord, getting, my lord, post-sale, my lord, notice claiming balance, my lord, payment, my lord, this, my lord, which we didn't know, my lord, an FIR is filed. My lord, kindly have a look at the FIR and, my lord, charge sheet which has, my lord, been filed. My lord, these relevant sections, my lord, are, my lord, section 318 of BNS, which is, my lord, cheating, 316, which is criminal breach of trust, 329, which is criminal trespass, and 351, my lord, which is criminal intimidation, and 79, my lord, which is, my lord, violating the modesty, my lord, of, my lord, woman. My lord, these, my lord, are, my lord, the 5 sections on the basis of which charge sheet has been filed. Kindly have a look at the charge sheet as well as the FIR. My lord, none of the ingredients of the offense, my lord, are made out. My lord, this is a classical case, my lord, form, my lord, quashing, my lord, of the proceedings. The, my lord, FIR, my lord, is, my lord, at page, my lord, 34. Kindly come to 34, annexure P1. My lord, kindly see item 12, original, on the first sheet, original written complaint is treated as FIR is enclosed herewith. Now kindly have a look at, my lord, the complaint. Kindly note the date is 9 December 2024, after, my lord, the post-sale notice. After we've sold the vehicle and, my lord, we, my lord, say, my lord, that balance is outstanding. Kindly come to, my lord, the second paragraph. But the most surprising and shocking fact is that local associates of finance company took away one JCB machine in my absence from site of construction in mid of May without serving any prior notice. Thereafter, I came to know machine has been sold also, whereas already paid more than 50% of loan amount against this machine. Balance 50 not paid. Again, on 3rd November 2024, some associates of finance company, namely Shomita Gupta and Benny Tyagi, legal coordinator, called the local police of Bagdogra, CSP machine, JCB machine returning from construction site at 10 p.m. from Goshaipur area without letting me know anything. There were 3 persons of my construction group present on the spot, namely Rona Shorka, driver Feroz Islam, site in charge, and Mohammad Miraj, supervisor. They were all told by the police machine is seized for having legal dispute with company, and so this will be kept in police custody. But my workers noticed that machine was handed over to those associates without taking that. Ultimately, machine was taken away. Such facts are not only unfair, but also illegal. Being a middle-aged lady and also a registered contractor doing government construction with liability, I'm facing immense problems. To continue, my such facts led me to suffer financial with huge loss of business, created acute mental agony, acute depression, anxiety. I talked to finance authorities several times, but they are avoiding me and instructed to talk those above mentioned associates to resolve. But whenever I contact them, they're avoiding me on several. Moreover, the so-and-so has also insulted me by using slang language and threatening over phone through unknown members of different states. Therefore, I cordially request you to investigate, etc. Now, my lord, not one notice to my client. My lord, charge sheet is filed without, my lord, the company who was a party to the loan agreement, my lord, being named as an accused, not even, my lord, in the FIR. And then kindly have a look at the charge sheet. My lord, it starts, my lord, at page 37. Kindly come straight away to, my lord, page 38. 38, my lord, and 39. My lord, identical, my lord, to the written complaint. Not one ingredient of the offense, my lord, of cheating. Not one ingredient of the offense, my lord, of criminal breach of trust. Not one, my lord, ingredient, my lord, of, my lord, the offense of criminal trespass, my lord, is mentioned in the charge sheet. Not one. My lord, your lordship reads it. Oh, they took this away and I'm suffering mental agony. And on that basis, charge sheet is framed. My lord, kindly see, my lord, at page, my lord, 39. And my lord, without, my lord, any notice being served on me, I am treated as absconding. And my lord, this charge sheet, my lord, is framed. Now your lordship's well aware, my lord, in hire purchase disputes, loan hypothecation disputes, my lord, taking possession, my lord, of the vehicle pursuant to an award which has the force of a decree, my lord, cannot be treated to be a criminal offense.
Where is
Secondly,
the arbitration?
your my lord, kindly take, my lord, the arbitration award. My lord, I'll give your lordship, my lord, the award, my lord, annexure P8, page 115 is the operative portion. My lord, paragraph, my lord, there are two awards. My lord, the first award, my lord, starts at, my lord, page 102. Kindly come to page 115, which is the operative portion.
Paragraph C, madam. 115 paragraph.
No, please let me place it. 1 minute. Page 114, my lord, paragraph 18 first. In view of the decision and the claimant company is entitled to an award for a sum of so-and-so, hence arbitral tribunal pass final award in favor to pay claimant so-and-so. Then my lord, directed to pay interest. Then my lord, C, claimants are entitled to take possession, repossession of the so-and-so, etc., surrender the possession of so-and-so, or maybe concerned directed to provide police assistance it required for the process. Claimant is permitted to sell off the vehicle asset, etc., etc. Now, my lord, your lordship's aware, under section 35 of the Arbitration Act, this is final between the parties. Section 36, my lord, which provides for enforcement, says, my lord, that it's deemed to be a decree, will be executed like, my lord, a decree. Now, my lord, we do that. And then, my lord, comes, my lord, this, my lord, complaint. The second award, your lordship will find, is at page 119. And, my lord, the operative portion, similarly, my lord, is at page 131 and 132. Paragraph 18. And I want to show your lordship, my lord, a reconciliation statement as well, which has been filed in a third arbitration proceedings.
Two awards mean two loan agreements were entered into.
Correct. I'm grateful, my lord. Two loan agreements, they defaulted in making payments. My lord, we went to arbitration. Arbitration, my lord, the award was passed in our favor. And my lord, because the machines were hypothecated, we were given liberty to take possession and sell, which we have done, my lord, with notices and, my lord, written to them that, my lord, we have not realized the full amount by sale, so we have a further claim. Once we write that, my lord, they, my lord, file, my lord, these proceedings. And, my lord, this is admitted even in the FIR that, my lord, at page, my lord, 35, my lord, first paragraph, that, my lord, your lordship will find that they have defaulted is admitted. Page 35, just one. I, Srimati Sarita Agarwal, aged about 49 years, contractor by occupation, resident do hereby. I purchased 4 JCB machines from so-and-so by financing, and I'm paying EMI regularly, except some months pending for 2 machines only. I already consulted with authorized. So, my lord, default is admitted, agreements are admitted. I don't know, my lord, how and on what basis the ingredient of cheating has been made out, or, my lord, for criminal breach of trust, or, my lord, criminal trespass when I'm acting, my lord, under, my lord, the award, and there is no allegation that, my lord, the contracts were entered into with the intention to dupe from the very beginning. And there has been no entrustment, my lord, of any property, my lord, in my favor by, my lord, the, my lord, complainant. So, my lord, the ingredients are completely absent.
Okay.
So, my respectful submission is, my lord, a summons order has been issued. My lord, kindly, my lord, stay the proceedings, my lord, in its entirety. This is a classic case
134 is the office bearer. But why?
All are office.
It could have been filed in a.
They were not stationed at the same time, at the same place, which you can see.
Okay.
Your lordship may pass a common order subject to what your lordship to and subject to what you can say.
At this stage, I'm passing separate orders. Let the other side appear, and thereafter it can be clubbed at the time of contested hearing.
It's also discretion.
This revisional application has been preferred by the petitioner for quashing the proceedings being GR case number 4269 of 2024 within bracket arising out of Bagdogra Police Station FIR number 405 of 2024 dated 14 December 2024 under sections 329 within bracket 3/316 within bracket 2 318 within bracket 4/79/351-235 of the Bharatiya Nyaya Sanghita 2023 pending before the Court of Learned Additional Chief Judicial Magistrate Siliguri. Stop. The petitioner contends that a loan agreement contains that he is an employee of CNH Industrial Capital within bracket India Private Limited, comma, a non-banking financial company. By dint of a loan cum hypothecation agreement dated number 34656 dated 28 November 2019, the complainant was granted a loan facility of rupees 2,224,448 by CNH Industrial company naam Industrial Capital India for purchase of machine invalid the case 770 X Magnum bearing registration number WB73F3368 and our loan cum hypothecation agreement 35042 dated 20th January 2020. It amount to 2289513. Same machine case 770X Magnum bearing registration number WB73F3394. The petitioner defaulted to pay the loan amount as agreed upon in the loan agreement. The dispute was referred to the sole arbitrator, and upon hearing, award was passed. The petitioner, in terms of the award passed by the arbitrator, took possession of the movables, namely the machineries. Yes.
Company of the petitioner.
Company of the petition. For a company of the petitioner. Awarded date, first award dated?
29 April 2024.
Both
of the same.
Okay, 29th April 2024.
No, both are same date.
Okay.
Both are.
However, no such criminal offences has been made out in the FIR. Mr. Paragon. Hence this revisional application. Mr. S.N. Mukherjee, learned senior advocate appearing for the petitioner, submits that the award passed by the arbitrator is a decree. Pursuant to such award, pre-sale notices were issued to the petitioner for taking over possession of the machineries. In the FIR, the complainant admits of default in payment of loan amount. No case of cheating has been made out. Cheating and other offences has been made out in the written complaint. He also indicates that no notice has been served to the petitioner prior to filing of the charge sheet. He seeks for stay of the proceedings pending before the Court of Learned Additional Chief Judicial Magistrate. Upon perusal of the records placed before this court, it is found that two loan cum hypothecation agreements were entered between the CNH Industrial Private Limited, Industrial Capital India Private Limited, with the complainant for advancing certain loan amounts for purchase of machineries. As per the FIR, admittedly there is default in making payment. An award of arbitration has been passed, and pursuant thereto, the petitioner being the, what is his rank? Petitioner in 134?
134. He is the relationship. He's the relationship manager.
Relation manager.
Relationship manager.
Petitioner being a relationship manager tried to execute the award passed by the arbitrator. In light of the above, I find that this court finds that an arguable case has been made out on behalf of the petitioner. Accordingly, there shall be stay of all further proceedings of GR case number 4269 of 2024, arising out of such and such, for a period of 6 weeks. Or until further orders, it is happy with petitioner shall serve copy of this application along with answers to the state through the office of additional public prosecutor, Jalpaiguri Circuit Bench, and to opposite party number 2 through registered field post with acknowledgement due and file affidavit of service on the returnable day. List this matter before the next available circuit bench.
My lord, may I just make one request where your lordship said I submitted, it's a decree. My lord, kindly say it's akin to a decree. My lord, that's section 30.
Okay, thank you. Akin to a decree.
I'm grateful, man.
Thank you. There is no such difference in the rest.
136, you also have passed order in 134. 136, again the relationship manager, my lord, absolutely same. Only in 135, it will be, my lord, the state collection agent. Sorry, state collection agent.
State
collection head of Odisha.
State collection head of Odisha.
Okay. Deep level expert for that.
Oh, thank you. Thank you. Company state collection head of Odisha. 34 and 36 are same.
Okay.
চলো এবার কোথায় যাবো আর নেই কিছুই নেই হ্যাঁ 5 মিনিটের দিকে নেই মোশন আর কিছু থাকলে দেখুন नहीं. Next. No.
Your lordship, kindly place this matter in the next circuit.
1 to 8.
1 to 8.
But there is a CRAN application for extension.
Yes, my lordship. 1 to 8.
देखिए 128. Who is for the state?
Nilay Chakravarti of the state.
Ankit, state or tomorrow.
Is that 129?
Lordship, I'm being led by my senior in this matter. Am I audible?
Who's for the state?
File है.
My lord, I am for the petitioner, my lord.
Yes.
Lord, this is an application for extension of interim order. Lord, we have filed within time.
Oh.
I'm sorry, my lord. I was.
Service has been completed. This is.
Yes, my lord. My junior is there. He will give the affidavit of service.
Affidavit of service filed on behalf of the petitioner is taken on. Who is there? There is nobody, Mr.
Nobody is there.
No.
I'm sorry, my lord. I thought my junior is there. Let it be not today. I'll do it this matter tomorrow then.
You'll conduct the one. चलिए.
Hello. Are go inside.
I mentioned item number 159 the lordship had asked to come at 3:30.
Oh. Now so?
159.
159.
Yes. Item number
into okay?
Mr.
Notice was issued by your lordship only in this matter, my lord.
159 दिन.
Doesn't.
Who is for the state?
But it's union, it's NCB. But guys, this is the first order was by your lordship under the notice and stay. On a question of law.
This case, my lord, Mr. Molingar, GST will conclude the hearing, my lord. And he is not present today, my lord. Kindly extend the interim order, my lord.
Only, my lord, I will request for one indulgence subject to your lordship's acceptance. But the issue is now pertains to my lord pre-cognizance hearing. Your lordship knows, my lord, NCB after. I just take 30 seconds, my lord. I will not waste your lordship's time. Just 30 seconds.
Yes.
It seems I have crossed the last one with our lord. But NCB after the investigation filed a prosecution complaint unlike police. Your lordship is aware. Now under the new BNSS, my lord, once a prosecution complaint is filed, whether it's by a public servant or a private person, my lord, there has to be a pre-cognizance notice, my lord. Otherwise cognizance cannot be taken. Now, my lord, this was heralded by the Honorable Supreme Court in connection with PMLA offence as well. Now, the issue now here, my lord, which calls for consideration, whether that ratio of, my lord, passed by the Honorable Supreme Court in connection with PMLA can be extended to NDPS offences also. That's the main issue. My lord, I'll be requesting for a leave to file a supplementary affidavit annexing the order of cognizance. But otherwise, I'll not be able to assist your lordship properly when your lordship will take it up.
Let him file the CRAN 7 of 2025. This is an application for extension of the interim order granted earlier on 28th January 2025. The interim order granted earlier on 20th January 2020, lastly extended on 8th September 2025, is extended for a period of 6 weeks, or the affidavit of service to lien or until further order, whichever is earlier. Mr. CR 32 of 2025, Mr. Oyan Bhattacharya, learned senior advocate appearing for the petitioner, seeks to file supplementary affidavit annexing the
Order of cognizance.
order of cognizance. Let such supplementary affidavit be filed within a period of 2 weeks. Please this matter before the next available circuit bench.
Interim order, please.
Interim order extended for 6 weeks.
Most of it.
Huh?
Most of it, sorry.
And within 2 weeks, we file a supplementary affidavit. Advance copy of such supplementary affidavit be handed over to them.
Most of it. Most of it.
Key. আর এখন কিছু করবো না, 3:30 পর চল চলিয়ে
Thank you. Easy pay.